Are you ready?
Judge Kavich,
Please.
I have Mr. Cardia, Kardia. He has two new cases, so two arraignments.
Do you want to bring them up?
Sure. I'm not challenging public cause this morning.
Okay.
I've already read it. So, Mr. Cardia.
All right. Good morning, sir.
Yes.
You speak English, correct?
Yes.
You're charged with 2 counts of possession of a gambling device, equipment, or paraphernalia. You were facing up to a year in jail and or a $4,000 fine. Looks like your counsel has waived probable cause, so I'm not putting any conditions on him at this time. We're going to reset your case. Just stay in contact with your lawyer. Do not pick up any new cases. Do you understand?
Yes.
Okay. Good luck, sir. We'll just have you sign a reset. You're out of here.
All right, Judge, bottom of 4, Bennett.
Are you guys ready?
Yeah, defensive record.
Okay, great. We'll start as soon as we get a jury about 9:30. We'll start.
Okay, so we're going.
Yeah, but we start testimony Thursday because I have a doctor's appointment
That's
tomorrow.
fine. We do have a motion to suppress. You're gonna want to do that today.
No,
Okay.
we do with trial. I mean, because my experience has been in the past, I've denied it, and then we got to do it all over again in trial, and I hate duplicating stuff. I have enough. You know what I mean? So,
So we'll take it up on.
yeah. What is suppression for what?
Um,
Just a stop, or is it the breath test, blood test?
kind of what's wrong. You have the stop, the arrest is made very quickly, and then if your honor doesn't find arrest at that point, the officer just takes kind of 20 minutes to talk with the DA. At that point, her body cam is muted, so I don't know what she said during that point, but she does talk to Officer Cavazos, who I've subpoenaed in this case, and kind of draws attention to. She calls into question whether or not she has the evidence enough, quote, saying, I'll call the DA and see what they think.
It's a double refusal, Judge, that's probably why.
Well,
It's a total refusal?
Yeah.
Did they get a
They have
warrant?
the blood warrant, Judge?
no, this is not a blood draw case. This is
Oh,
a,
double
this
check.
is a consent case, but, so there's that, she does that for 20 minutes. Then she.
So it's basically just legal issues?
Well, yeah, and then she reads the DIC 24, so at that point, he's definitely under arrest at that point. But then he said consents to the blood draw, they get to the hospital. He withdraws consent by saying, no, give it a judge. And with a warrant, and then the nurse keeps chiming in and says, are you gonna give me consent? Are you gonna give me consent? So there's an issue of withdrawal.
Did they end up getting it or no?
Yeah, he ends up reconsenting, but at the request of the nurse, who's not a law enforcement officer, so the withdrawal took place at the hospital. So it's kind of, you have, like a PC, withdrawal consent, like a consent, in my opinion, and then
Okay.
possibly prolonged.
That's not like it, whether or not it's.
How many witnesses do you have? 4?
For this one, Judge, let me just confirm, she did send me the list of all the witnesses. Four witnesses, Judge, 4 witnesses.
Do you have any witnesses?
I did subpoena Officer Cavazos, that can.
Well, is he on your list, Cavazos?
He wasn't on her list, Judge,
Okay.
but I did have her reach out to him.
The only reason I need him is because the state wouldn't stipulate to the admissibility of his body cam footage, so I'm literally only.
Oh, yeah, look, you do what you need to do. Really, it's not a big deal. Okay.
Even for suppression, but if you deny.
Yeah, we'll
suppression,
keep, for sure.
authenticate.
Yeah, I don't know yet. We still got to see more, obviously,
Yeah,
but,
It's all body cam, so you
Yeah.
can just kind of watch and see what you think.
okay, just be ready. And then about 9:30, we'll start.
Perfect, thanks, Judge.
Judge, this is Bennett on bottom of 4.
Sorry, I just got to do the PC forms on,
Yes, sir, some of them are ready.
ready. Yeah.
There's an assault family member complaining and defendant were in a dating relationship. Officers were dispatched in reference to a prior domestic assault. Upon arrival, law enforcement met with the complainant, who stated that on 7/18/2026, she and the defendant got into a verbal argument over his infidelity. This was reported on August 10th, 2026. Complainant stated defendant then pushed her down the bedroom and dragged her to the living room. Complainant stated defendant then hit her in the face, causing pain. She had to go to Texas Women Hospital the next day since her toe wouldn't stop bleeding. Complainant had a video of the assault through their interior security camera and photos of her injuries. Law enforcement reviewed the footage and observed defendant dragging complainant in the living room, pushing her into the furniture, and throwing two unidentifiable objects at her head. Though it wasn't clear if they made contact due to the quality of the video. Officers then spoke to the defendant, who initially denied any knowledge of the assault, then stated that complainant got mad at him for going out and drinking. Defendant stated that complainant started throwing his things around the house at him, pushed him and slapped him twice, stated that they were both drunk, and he was detained without incident. Judge, he has no prior criminal history.
So you're saying that he slapped her? Is that what you're saying?
He slapped her, pushed her, to the furniture, dragged her in the living room, and.
Did she attack him first?
So based on the observation from what law enforcement saw, Judge, in the surveillance video, it was consistent with her statements. There was no indication about any abuse. This is what he said.
Oh, I see. Got it. Okay. Mr. Bennett, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using, I will revoke your bond and put you in jail. You understand?
Yes, sir.
There will be no more PR bonds for you. This is not a revolving door. There's a protective order in place and you need to get to know it. If you violate the protective order, they can file additional cases against you. And the violation of a protective order, it's one of the worst misdemeanor cases you can pick up. Do you understand? Do you mind printing out? It's like just at least the first page so I can amend it, put no contact. We're going to reset your case to give you time to hire a lawyer. So when I mean no contact with the complaining witness, I mean no contact at all. Phone calls, text messages, emails, Snapchat, social media, just don't. Otherwise, just might not end well between us. Do you understand?
Yes, sir.
All right, we will have bond conditions created for you to sign, states bond conditions. I'm going to have you sign a reset. We'll have you take a seat in the jury box. And then once you sign the conditions, you'll be out of here. Come on. So if you can file no contact,
Yes.
or no, actually, don't worry about it. Don't worry about it.
Yeah, it's on there.
I'm going to monitor.
Okay. But he's doing it, right? Yeah.
All right, top of 9, Cormier.
You were Mr. Cormier. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Oh my God, he's on probation for a fault FSRA involving injury. Please.
Yes, sir. On August 11th, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a 2021 Honda Accord remaining stationary in a moving lane of traffic. A traffic stop was conducted and the officer made contact with the driver, the defendant. While speaking with the defendant, the officer observed him to have glossy eyes and slurred speech. The officer asked the defendant if he consumed any alcohol prior to operating the vehicle, and the defendant replied, yes. Field sobriety tests were then conducted with 6 out of 6 clues on the HGN, 5 out of 8 on the walk and turn, and 2 out of 4 on the one-legged stand. DSC was read, and the defendant consented to breath test, with the results being a 0.129 and a 0.125.
Mr. Cormier, I'm going to find that there's probable cause to go forward with your case. I'm now taking away your privilege to drive. You are not allowed to drive at all. I don't care what the heck you have to do in this life. Because you're on probation for a failure to stop or render aid involving an accident, you have a priority to BI. There's another FSRA. I'm now requiring you to place a scram on your ankle so I know that you're not consuming alcohol. You are not to consume alcohol or illegal drugs, and I will test you like crazy to make sure that you're not using. I will deem you a public danger if you violate these conditions. I will put you in jail, and I have no problems making your bond as high as the clouds. Do you understand me? This is an affidavit that you're going to sign today, indicating that you're going to promise me that you're not going to drive. If you do, I can have a contempt hearing. Every time you drive, I can slap you with 180 days in jail. And I can stack it. Do you understand me? Can you file the guardian interlock paperwork, please? I'm sending notice to DPS in Austin. You are not allowed to drive. I'm also indicating that if you do drive, you're not allowed to drive any vehicle that doesn't have an interlock. So if an officer pulls you over, that car doesn't have an interlock, they're going to take you to jail. As it stands now, you are not to drive at all. I don't care what the heck you have to do in this life. You understand? All right, we are going to reset your case to give you time to hire a lawyer. I'm going to have you step on over here. We'll have you sign a reset and we'll get you out of here.
All right, Judge, next is page 17, Jones. Come on up.
Good morning, Ms. Jones. Ma'am, you're charged with two cases. You're charged with terroristic threat of a family or household member. You're also charged with criminal mischief. On the terroristic threat, it's up to a year in jail and or a $4,000 fine. On the mischief, it's up to 6 months in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
To preface this, the complaining witness is the defendant's niece. On August 10th, 2026, an officer was dispatched to 8005 Talon Street in Harris County, Texas, in reference to a family disturbance. Upon arrival, the officer made contact with the complaining witness, who stated she had a listed location, which was her grandmother's house, for a family gathering. The complaining witness stated that shortly after she walked to the front door, the defendant initiated a verbal argument. The complaining witness stated the defendant then said, "I don't care that you're pregnant, I'll beat your ass." The complaining witness stated the defendant lunged at her after making the statement, but two witnesses were able to hold her back. The complaining witness also advised that the defendant grabbed her iPhone during this altercation, valued at $600, and threw it on the floor, causing it to shatter and become inoperable. Both witnesses confirmed the complaining witness's story.
Ms. Jones, I'm going to find that there's probable cause to go forward with your case. You are not to have any contact with this complaining witness and not to be in possession of your weapons or go where she lives or where she works. Do you understand?
Yes, sir.
If you violate this condition, I will revoke your bond, put you in jail. There will be no more PR bonds. Do you understand? Do you have the ability to hire a lawyer? Do you have the ability to hire a lawyer?
No, sir.
What do you do for a living?
CNA.
Okay, so how much money do you make a month?
My bill is over.
I don't know. I didn't ask your bills. How much do you make on a monthly basis?
I take home my 26, 25.
What's gross? 4 grand, 5 grand?
Something like that.
Okay, you're not going to qualify for a court-appointed lawyer. We're going to reset your case to give you time to hire a lawyer. I'm going to have you sign a reset. I'm going to have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go, ma'am. Please. If you can file no contact, no weapons, please, on Ms. Jones. And no going back to the house.
All right, Judge, next is 29, Tolliver. All right.
Around the other way, please. Good morning, Ms. Tolliver. Ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir. On July 11, 2026, an officer was dispatched to 7230 Wisteria Chase Place, which is a residence in Harris County, Texas, in reference to a family disturbance. The caller stated the sister was driving erratically as she drove their mother's vehicle in the front yard of the listed location and ran over the neighbor's mailbox, then drove off. Upon arrival, the officer made contact with the witness, who stated she observed her neighbor, the defendant, drive through multiple front yards and then hit mailboxes. The officer then spoke to the complaining witness who stated it will cost $500 to replace the mail.
Does she have a license to drive?
1 second, Judge. Yeah, she does.
Ms. Tolliver has a license? Okay, ma'am. As a condition of your bond, you're ordered not to drive unless you have a valid Texas driver license and liability insurance in your name. You were not to have any contact with any of the complaining witnesses in this case. If you go over to their house, if you try to have contact with them, if you have a weapon, I will revoke your bond and put you in jail. Do you understand? Yes or no? I'm going to protect my community at all costs. If I have to put you in jail at a $50,000 bond, I mean, I'll do it in a heartbeat. How old are you, man? You're 19. You're 18. What do you do in life? You do what? Okay. Deputy will give, let me see if I have an application.
Says her license shall expire. Yeah,
So she doesn't have a license.
correct. It shall expire as of 7/2/2026.
Okay, Ms. Tolliver, let me make something very clear to you. I don't think there's anything that makes me more angry when I have someone who drives without a license and insurance, especially after I have you sign an affidavit. You're going to promise me today that you're not going to drive. I don't give a rat's behind what you have to do in this life until you are legally valid with a Texas driver license, insurance in your name, and approval from us. If I find that you drive, I'm going to go bananas on your bond. Do you understand? Don't tempt fate because it might not be nice to you. Deputy's going to give you an application for a court-appointed lawyer. I need you to fill it out. I'm going to have you come here, swear to us that you're not going to drive, and then after that, we'll get you to fill it out and see whether you qualify.
That's it for now.
Okay. On that, can you also file no contact, no weapons, no going to the house? Ms. Hudson, are you ready?
Yes, sir. I have Mr. Lee.
Mr. Lee.
Yes.
Hey, you ready? Lee is the first one. Has he paid the DAP?
He was supposed to pay it this morning.
Lee?
We checked in.
Okay, I guess we'll hold on him. It's 210 days old. If he hasn't paid it, he's getting rolled until tomorrow.
Okay, that's fine. We got his PTI contract this morning. So he would still need time to get the device and everything as well, though.
Oh, it's. How did you get us so late, Miss Hudson?
I'm sorry.
It was on 8/3. The TRS was pending for them to do the contract. It looks like they got the contract, recommended IOP, SOP, and they sent it in this morning at 8:00 in the morning.
Okay, I'm putting you on for Tuesday. If he
Okay.
doesn't have it by Tuesday, I'm rolling him day for day.
Yes, sir. The next one is Mr. Nguyen, Nguyen.
Okay,
For
where are we
that,
with this?
for that one, we want to apply for the PTI.
Okay, you're at 160 days, so I'll give you a week to get the packet in.
Yes, sir. Thank you.
And then he's got to be here if it's not done, or he's got to be here regardless to go do a TRS. So,
Understood.
Understood.
okay.
May I be excused, Your Honor?
Yes, ma'am. Have fun.
Thank you.
Yes, don't want to yours today. Okay, now it's September.
Hey, I have a non-disclosure.
What was the last one?
Lawrence. Yeah, do you mind taking, just let me know what your position is?
I don't know that.
No objection? Okay.
No, it's something. Yes. It's just like a lot of city learning. This is not. She's trying no, no, about her. Oh, I agree. What she's doing, if she was like that. I understand. The executive trash.
What about for the big?
Lee?
If Lee doesn't appear, I'm revoking the bond. Oh, he's here? Okay.
Lee? Good and stuff.
And you're so let's say I'll say where is that? But she doesn't go. And it was only a half day.
There you go. There you go.
It's like still in home. Just doing here, it's very, very. And. You know, text. And he used my stand for like getting the qualified work, we were qualified. It was like the year 7. Like working on. Working on.
But honestly, I think the first responders was like the teachers and the family.
Yeah.
Thanks.
Like I spent more on daycare. And then now, like, it's even more, like, if I have a 3-month-old. Yeah, I don't need to, like, we said, like. That's just not. So, like, I mean, at least I'm going miles.
Judge said,
Did you send him for a test this morning? You did? Okay.
Mr. Robertson, you got a friend across, he's going across the street. So. I'm gonna give you 7.
There might be some museum, but no use. Or they're actually at the Bible door.
Hey, Veronica, on Robertson, I'm looking, did we order him to have an interlock? Because it looks like he was in lockout in the felony case.
He has a screen device.
Okay.
Apparently, they're moving. I just get past now. I'm losing a phone.
Just make sure he's.
What location do you have? Okay, did you guys evaluate mine? Is that? Okay, you good? Okay, I mean, did you talk to the school district operation?
That's what she was looking for.
Yeah, we're
Not
gonna
that
do
extra,
it.
but, there was something else that we wanted to talk about. She was gonna meet with them.
So you need to reset?
We're gonna reset the tree on the screen.
Okay. So that's a good one. Any points, Judge?
Please,
You want to start with the trial case or the DVR?
I don't care.
Trial case, Mr. Carroll.
Okay,
I've been told they're going on something else.
I don't know yet. We're still waiting. Make sure that it happens,
Okay.
but assuming you do.
I would like to go today if possible.
Stay ready on Carol.
Okay, I guess just give us a minute.
Sure, sure.
Um,
Then I got Mr. Mitchell, he needs a couple of weeks to do, get everything sorted out for PTI.
Page 23. So they.
Mitchell's 200 days. You guys received the contract on 8/5.
Yes, I think he has an appointment this week, Judge, to get this.
Is he here? He's not here.
Mr. Mitchell?
Oh, he is here.
Yeah.
Okay,
He didn't check in, Judge.
come up, Mr. Mitchell.
Yeah.
Do you have your appointment for today?
Thursday.
Thursday, okay. Have you paid the DA fee already? Okay, do you want to roll it till Monday? Make sure.
Whatever the pro wants, if he.
I'm okay with that. I'm cool with
If he
that.
turns everything in, he doesn't have to appear on Monday.
Yeah, if you get everything to Mr. Martinez, so they're ready to file a supervision order, then, yeah, then as soon as you do, give all the documents to him. If he's got everything and he can come to me and she's ready to file the supervision order, I'll waive your appearance on Monday.
Okay.
Great, okay. This is like a topic.
Just, we'll have you sign a reset and then after that, you're free to go, Mr. Mitchell.
I'm not talking about the peer, about it.
Yeah.
Let's go then to Mr. Corzette. I think that one came back retested. I remember one of these two, they retested and came back at 0. To do that? Oh, go ahead.
Is it Crusoe,
Corzette.
right? What's it, Karina, what say you on Crusoe?
Reset much?
BBR.
I know, but is there a 0? If so, the case is 57 days old. It's probably best time now to send it to the lab, how they do when you get zeros, you know?
No, what do you mean? Is it?
You said they came back zeros.
No, his subsequent testing. I told you BBR.
What?
One of the two today I have. I think I have these.
Yes, but this isn't one of them.
Okay.
Just kidding.
Just kidding.
So for that one, Judge, he has a bond violation and his bond violation was for high draft, 0.047. He retested within 15 minutes and blew 0.045.
Come up, Mr. Crusoe.
Judge, on Mitchell, how much time did you get?
Next week, beginning of next week.
Here's way.
No. Listed as must appear unless he's got everything.
Oh.
But what does he have now? Mr. Crusoe, I only ask one thing from you. You either have a problem or you just don't care about bond conditions. The evidence tells me differently, sir. What am I supposed to do now? Just let you go? Because then I'm telling you it's okay for you to do what you're doing. And it's not. Herman,
Yes, sir.
ball's in your
I
court.
was hoping that we could change it, since this is first violation, the case isn't that old, Judge, that we could potentially go to Scram to, and then properly.
Do you see any more violations? And any more positive tests between now and then?
It's off, I mean, it's not.
I'm now going to modify your conditions to put a scram on your ankle that detects alcohol 24/7 through the perspiration in your skin. And let me be frank with you. This is the last thing I have at my disposal before throwing your ass in jail. The next time you test positive, and I don't care what it is, if it's a tequila lollipop, hair dye, whatever it may be, mouthwash, you will go to jail and it will make your bond high. Do you understand me?
Judge, may we keep it, reset date?
Yeah, whatever you want.
Thank you,
Herman.
Judge.
But he gets a scram device today.
Yes, sir.
Take a seat for me, sir.
Right this way.
Hey, Etch, when are we getting a jury? Do you know?
We have a jury judge. I just got the panel for us. I'm just waiting to see defense counsel.
I'll take the.
You want to get the panel? I think it's ready. Yeah. Okay.
Just so we can start running it.
Yeah. Okay. Who else you got?
OSA, OSI. I think that. All right.
I like it.
Yes, and make sure my office and everything on you.
Twenty-six, that ordered client to obtain a portable apply with all testing protocols. Client was advised to retest in 50 minutes once a high brack is blown. Client blew a high brack of 0.059 on 8/3/26 at 11:29 PM, and client failed to retest within 15 minutes.
Jones, Whitney.
Mr. Osei, do you have anything you want to say before I drop a gauntlet?
Did you blow afterwards?
That's what's in this.
Okay, yeah, they're not doing this, I'm saying.
Yes, please, no. 3 bond violations, Mr. Osei. It goes with you. I'll set the bond at 5,001. Actually, 5,003, because it's the 3rd bond violation.
Well, you gotta put it in the document.
Yeah, he'll auto-populate tomorrow. But if you want to, I mean, unless he bonds out, same conditions will apply. Actually, no. Scram. If he bonds out, he'll have to come back the next business days to get it. If he's here tomorrow, then I guess we'll talk.
Judge, how much was the bond?
5,003.
And what would you like me to do about the trial case, Judge?
Just give me 5 minutes. Should we reach out to Cedillo, JP?
The attorney that was here earlier, that was.
Yeah, but it's under JP's name. He's the one that's got to try this thing. Or are they both listed as attorney of records, you know, on the trial case?
Is there? Yes.
Yeah.
So I'm gonna put, I'll say for tomorrow, just from,
Yeah. Yeah. So both of them are, okay, great. All right, then that's good.
well, just hang out. So, yeah.
Yeah, I'm calling him now.
Okay.
Telephone number 832-709-3653. Can't take your call.
Oh, that's right.
Judge, good morning.
Hey,
Trust briefing.
yeah, give me one. Come on up, but do you want to give him, do you want to give him, are you running the list?
Not Judge, our investigator's here, so can we get the?
Yeah, I would say let's give it to him now, so might as well.
Oh, so he instead of to go to the.
Can you not give it to him to run?
I can't give it to them.
Telephone number eight.
Okay, not a problem. I'm calling it.
Zero, 9, 3, 6, 5, 3. Can't take your call.
Yeah, Veronica's ready.
Oh, hey, I need you, please. We need you to take a look at the list real quick because we need to get it to run everybody. Jury's on the way. Is Cedillo coming or no?
He'll be here, but if not, it's not, I mean, so he's definitely speaking to her, so.
Okay, so you're good.
Yeah.
Okay. Herman, go ahead and reset it.
Okay.
Not too far, but reset it.
Yeah.
These are just our copies.
I'll say.
Yeah, I think he's handling some other settings.
Not a problem. I don't know if you're gonna be by yourself or.
Yeah, I'll couple now, I'm thinking.
No, don't take anything, no, because most defense lawyers at least have two.
Yeah, Mr. Pimentel should be.
Okay, great. Hi, welcome.
And then JP over here too.
Okay, sure. Okay, counsel, I'm sorry to keep you waiting.
No problem, Your Honor. Robin Lit is on docket, LINTON.
Okay,
There was a motion to withdraw, I heard by our attorney. Not my motion. I would like to sign a motion so I can step into the case.
oh, you're gonna sub in?
Yes, sir.
Do you have a motion to sub?
I did not do a motion, so I found out about the motion to withdraw my way here. I did an attorney record.
Look on the, can we-
You don't have to show that.
look, if you look on the tower, we may have a motion to sub. Do we have motions to sub? Yeah, if you look in there,
Yeah.
Okay, so she was on the reminder. It's only 67, so you just update the name for him. It's just.
Yeah.
Because he's gonna sign his condition.
great. I don't like to grant a withdrawal unless we can put someone else in, because I don't like to leave them without a lawyer.
That's fair, Your Honor. No problem.
Thanks.
29, October 1st.
I'm setting for Ben at the daytime.
I can bring shit that I would.
Ramona, did you see how many trials we have on the 25th?
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 trials.
With 188 guys. Pretty much covering all of them.
I mean, can we send one to ERD?
We only got one prosecutor judge, so how do you do it?
Mr. Carroll.
There is no ERD.
Well, preparation.
Yes.
And they're all oldish. Well, DeGuerin's not gonna go. DeGuerin's not gonna go. That's set because of upstairs. He picked up the murder case, remember?
Got it, okay. So I'll make sure that she is aware of that.
So, well, at least, talk to felony to be
Well,
used.
On that day, Green is set.
All right, any questions?
Green is the one with the, speedy trial.
Okay.
Yeah.
Do we have, are any of those jail cases, do you know? Jail?
I think, all right, that's fine.
Because those will take.
I'm sorry? No, it's good to go.
Okay, I just followed your name up.
Is it that pretty flowers?
I'll have to go one by one to check that, or no.
Hi,
Ma'am, reapproach.
please.
Thank you.
Do you have someone else?
That's it, Your Honor.
Oh, okay.
Give
Yeah,
permission.
yeah. I'll grant it. I'll grant the motion is up now. Or
Well, it's in the
All right.
Linton?
Linton.
It's the one that I had to clear the email. I'm sorry.
Alright, so we're on. Alright, so since we have a list of leaders, I'll come up with how is September 22nd? It's gonna be the close setting to consider all.
Please, one
And stay on the third, wait for parents. To consider all the following will be set. All right. Sorry, you're gonna ask for it. All right, and sign.
We just got.
Right.
Oh. Yeah. I know.
Oh, yeah.
We have here today underscore.
What do you want me to do? I mean, it is what it is.
That would be.
So, it is what it is. No.
This case.
Actually, that's the oldest.
No, we have to do Yaha first. It's 381 days. Yeah, that's what we're going on. And we can carry it. If you want to see, but I've got one that's, you know, he's complaining about speedy trial. I've got one that's 360 days, 380 days.
And then there's one that's 305.
Yeah. Yeah.
Hey, Judge,
Hey.
come say hey.
How are you?
Pretty good to see you again.
You too? What's new?
Nothing.
Hey, I'm live streaming, just so you know.
Okay.
Just,
Well, want to say hi. Good luck in the trial.
Thanks.
Okay, I don't see. Oh, yeah. And you're on here, like, across the board. There's these things. I'm not sure. Yeah, we just started. So we're about. Yeah. It was kind of small. You got all of it. So I was like, try to know. Like, all I know is school. And I'm good at school. I'm like, learn something new. I started.
Hi, yeah, of course. Hey, I'm live streaming, by the way.
My son at the start of hospital, LSU.
Oh, thanks. Wonderful, great. If he ever wants to come and hang out, tell him he's welcome to come hang out, put him in the chair and let him watch.
I will do that when he's all there.
Maybe he'll get a tasting for criminal defense sign or prosecutor.
He likes it. My husband, his dad is a police officer, so he's maybe not that.
There you go. Yeah, so we're happy to have him anytime. Have him come in. Thanks. Sweet. Yeah, we're not gonna wait. We can't wait all day. Okay, then do it. How old is it? Okay, all right. Okay.
Yeah, I'll take it.
Because I also like this one, but I think there's another. Is it online or is I would love, yeah, 29.
Mr. Vaughn, what's the word, Thunderbird?
We try to be obviously on it. But the state.
It's
needs to do
50
a-
days.
The state needs to do it.
So Judge, we did submit the complaint, we spoke to the complaint, they're still on board, we have an offer in there. Defense does want to provide us some mitigating factors in regards to like evaluating to see if we would consider dismissal. So I advise them to email it to us, because today I cannot look at it.
Obviously.
Yeah.
So why don't we set it a week? Can you set, how old is
Can we
it?
do two, Judge, just because next week we have all the stuff and we don't have to.
Okay,
Thank
2 weeks.
you.
Thank you, Hannah.
bye, Mr. Wong. And mitigation packet. Hey, but how old is it? I didn't even, it's,
Third case is 887 days.
ah, damn. See? But they don't have the rip done. What am I supposed to do? Yeah, okay, so 2 weeks, but I'm not waiving his appearance. You gotta be here. Okay, okay.
Did you send a mitigation pack?
No, and I have. A civil matter.
I lost my telephone. It's over here. Please, we're on there. And then you'll have to go. We end up things also. No. But it's a different reason.
Mike, I want to let you know that, you know how you got the jury one? Because I was a jury one.
Yeah, what, it's not cool to let them wait, you know?
Right, and then I like it when you start early.
Yeah, that's the way. I don't want to be here all day. And they don't need.
That much better.
Yeah.
And when I was a jury.
Yeah, it happens. That's why it's, the earlier it is, the more awake.
Yeah,
You
you
know?
start early in the morning and then close early. I think that's a good.
Yeah.
I think that's a wonderful.
Thanks.
What about tomorrow? No, it's not. I
don't know if to go over yet.
Yeah, hopefully other.
Hi, JP. What's up, buddy?
He's our first round.
I know, cool.
We hitting all the other ones. Do we connect for audio, video? Do you connect via Zoom? Do we use the?
Yeah, that over there. Mhm. Yeah, 20 to 30 minutes in Vordaer. And then we'll start testimony Thursday.
Gotcha. Do you like to do motions, limiting such?
Limine we can do before. I see, why don't we do the limine before, but the motion to suppress will carry it.
Okay.
That way we don't have to duplicate.
Sounds good.
Yeah. How many limines do you have? Have you looked at the limines?
That was Justin that had the child period.
I know, but I have a doctor's appointment tomorrow.
Oh.
And I've been waiting months for it.
Oh, geez. Well, it's,
Yeah, it's just drama.
you just gotta get the date.
It's called getting old. I'm going through menopause.
Can't even tell, Judge. Okay, well, the reason I also asked is because they're doing jury on it, limiting, I have to run upstairs to some film.
Do you want to talk, Karina, are you familiar with the limines in it at all?
I can approach it if you judge, nothing pressing.
Okay. And we can do it afterwards.
That might be-
I don't want to keep the jury waiting. As soon as they get here, let's start. That way.
that might be best, Judge.
Yeah, that works.
Yes. I use some related upstairs. Sometimes asking for help instead of like trying to. Everyone does.
Well, I got some better ones for gun.
I know, I hate that one. Everyone does. Okay, John will text. No one's gonna text. Okay.
Judge, we also have sentencing on Thursday also.
Right, but that shouldn't take very long.
No, it's probably not, because just, you know, somebody ready.
See something about cocaine, was have a life test. That's why you make her.
If he wants to wait, you'll have to. And I
Valdez, John Valdez.
Or Judge Manfroshi?
Yeah.
Just give you an update on Enrique De Leon. We submitted mitigation yesterday, which was required before today. We just need to reset to see if it gets approved.
Enrique De Leon.
Okay, pick a day next week, any day.
Next Wednesday.
Sure.
Okay, required?
Yeah, because yes, because if he's approved, it's over nearly 200 days. He's got to do the TRAS. If he's not approved, you got to come take care of it.
Sounds good, Judge. Thank you, maybe excuse.
You got it.
Next Wednesday. See if he gets.
If he does TRAS, if not, then he's got to, it's clear trial.
Mr. De Leon, please come on up.
Hang on, Fleischer. 5,003. Yeah, please, on all of them.
He's allowed to read PC, as long as I'm available, so they're requesting from backup.
Say that again.
I'm gonna run downstairs and put more really quick. He's allowed to read PC or just a tour as long as I'm available.
I'll wait for you.
Thank you, Judge.
Hey,
Judge.
Hi.
Judge, I'm approaching on Noah Scott. I spoke with Brianna this morning. They're still waiting on blood for this particular case.
Yeah, it's just,
Yeah, I just wanted to ask, to make sure you'd be okay. Mr. Scott, I had a trip planned, going up to Chicago, we'd be meeting, family and his childhood best friends.
is he here now?
Yes.
Great. We'll send him for a test. Hopefully he's negative and then, okay, great. Yeah, all right.
I just wanted to make sure you were okay with it.
Yes, yeah, just let him know at some point.
I said, hey, don't be
Yeah.
same rules and then probably
Right.
when you get back.
Yep,
Okay.
For sure.
Just want to make sure.
Yeah.
Thank you, Your Honor.
okay, thanks.
They're waiting.
Yeah.
Just don't have to, so she can be attached. I mean, he's like.
So,
The new notice of hearing, council.
sure, yeah,
Yeah, we can, since we'll start this one.
just do, I guess, another attorney record and we can attach her that way. Yeah.
Just one of ours.
Yeah, why not?
We can follow it after. today.
Yeah, I mean, she's not appointed. She's,
No.
we'll put her as retained. Yeah, yeah, okay.
And then the only other thing we're following this case is just a motion for protection, so we can get to 5%.
Sure, of course. I mean, if you're in trial, that you're in trial, they can't take you.
Child sex case on Thursday, we should get a continuance on it. You never know when you already.
You're already in trial.
Exactly. So it should, yeah. It'll just.
Yeah, you got it, man.
The next one after this will be. I think it really work with shows. Yes. Same for that one. I just told you yesterday.
Maybe.
I'll just check this in the start. Okay, thank you. Council for the start. Victoria, you know, on the leave, I love the I know I don't tell them yes. She wants to get connected. You already sent her one night, yeah. Yeah, good one. Is discovery complete? All right,
I'm gonna say. Let's go check the report.
Yes.
You see, Jen, and it's right.
It just.
So I think there's.
Yeah, sorry.
I want to start. So this I just used
Was the application submitted? Okay, well, do we set the fire department? How September first to the third?
How can I help you?
Yes.
No, I just use the same.
Oh, it's a regular.
Two by seven.
796.
Who's got that?
Yeah, that's all great. We'll have to go to the virtual. They have to be able to working as a summer state. Yeah.
Hey, jury's here. Okay, guys, come on up. We've got to bring a jury in. Talk to me. Hi, Sean. What's up, buddy?
I have the Pearson, it's the bond violation with the spray and arrested for the ETG.
Okay,
Yeah.
I,
One of those fun ones where they say it has something and then I have to go take the test with the permit.
that just you blowing.
Oh, no, it's each of yours, so.
I know. Come up, Mr. McPherson. Were you set for trial today on it?
Not today. We had a future date set.
Yes, ma'am. And that's,
I don't know what to tell you, man. Yeah, but I can't let you go now. It's a second bond violation. If I do, then what's going to happen? Over and over and over. I cannot continue. I usually try to give everyone the benefit of the doubt on the first one, but I can't just continue to do that because at some point I become an enabler. Do you understand what I mean? Right.
And I think, so just to clarify, on the first one, there was late lows when you had a portable.
It
So you-
doesn't matter.
But you
There's
get confirmation that he didn't actually. That's kind of the problem.
on what?
On the, so he had the scram violation popped up 8/8 while he is asleep, right? Then as soon as he knows about it, which is 8:10, I send him for an ETG test. Right?
How long after?
That would have been less than 48 hours. So
Yeah.
it's within its realm. So 72 hours is the realm of reliability for an ETG, and then it's an additional 48 hours for kind of reliable. So it falls within that deal where he hasn't had any alcohol sulfates in his system. So I don't know what else we can do other than showing you that he hasn't consumed alcohol. Scram, we've been having like consistent issues.
Well, then I get it, but then it's his responsibility to go get it taken care of. It's a second bond violation, man.
Right, but
Alcohol dissipates out of your system out of an hour. If you have a drink, it's out, and then it just,
but the sulfates don't, right? And so that's the issue. Is like, I understand if it was a blow and I showed that, that was the case, of course that would make sense.
this is supposed to be even more reliable, Sean.
What's that? Sorry.
This is supposed to even be more reliable.
But
Look,
quite frankly,
regardless,
it just
regardless,
isn't, though.
I'll put them on for tomorrow.
Okay.
Bring all your paperwork, show me what you have, but I don't know what to tell you. It's a second bond violation. I can't just continue to, it's at 1 a.m, man. You know what I mean?
Sure.
Really.
No, I
So
understand.
I'll give you the benefit of the doubt again. We'll roll it to tomorrow, bring everything you have, bring everything that you show me that it's gonna actually test 48 hours after the fact,
Sure.
what it's gonna test, how reliable it is, and then we'll have a hearing.
Okay.
But just no promises, man. It's a second bond violation.
Would you be okay authorizing the pretrial services to give me the reports from the spring?
Sure, of
They want
course.
it to me unless
Yeah.
You say so.
Yep.
Okay.
Okay, roll to tomorrow. All right, just take a seat for me. Come on up. Guys, come on, tell me. I got a jury waiting.
Just bond conditions.
He's in jail?
Yes.
We don't need conditions. Yeah, okay. Thanks, you too. Hi.
Judge, we have a defendant who is ready to waive.
I need him out, please. Who is it?
It's Kevin Smith.
Sorry. Okay. Does anybody else need someone brought out?
I think Darren Williams, yes, sir. Darren.
Can you bring Williams too, please?
And Smith.
Mr. Francis, what you got? Mr. Francis, talk to me about your guy real quick.
Bond conditions, Judge. Looks like there were no bond conditions signed.
What's the last name?
Williams.
He's in jail?
Yeah, first name Darren, Daron, Williams.
Are you anticipating him bonding out?
No.
I'm still, it needs to be signed.
Well, I mean, when they bring him out, they can sign him then.
Okay,
But
okay.
I don't even see him on the docket.
Here's Williams, judge on page 32. He bonded out.
Oh, well, I asked him if he's in custody. He said yes.
No,
So-
he's not.
Okay, he's not in custody.
Oh, I apologize, Judge.
Darren Williams, come up.
He doesn't know.
And he's not here.
Yeah, good. Who's homeless to begin with?
I get it, but if he's not here for bond conditions, I'm revoking his bond, 5,001 if he doesn't show up.
Okay. Ready to make some phone calls?
Counsel, you ready to talk?
I'm waiting on a plea, Mr. Bowers, as they bring.
It's it, okay. You're not ready, okay. After Justin, I'm bringing the jury in, guys, okay? We're about to pick a jury.
Justin,
Or wait, this might be, what's your last name?
Smith.
Smith. See, with you? Smith? Is it Kevon or Kevin? Kevon, Mr. Smith. You are wanted out of the state of Louisiana, specifically Jefferson Parish, for a failure to appear. Just doesn't tell me what, but just a failure to appear.
Misdemeanor case is 2020.
Well, you got a failure to appear now out of Louisiana. Did you want to waive extradition?
Yeah.
Okay, great. We'll just have you sign the paperwork and you'll, within the next couple of days, you'll be back. Okay? Just give me a second and then. Hey, Deputy Williams, can you help him sign? Okay, thanks. That's it.
I'll give you that.
Dane, what you got, man?
Judge, our money legged on your docket. We sent for a plea today. There was a miscommunication. Lives in Chicago.
Let me see how old it is first. If it's super duper old, then I'm not gonna, it's 250 days old.
The reason it's that old, Judge, we were trying to get him into PTI. We got him all the way to the end line on the PTI. He took a job in Chicago and he's just not gonna be able to do it. So he's just gonna take the time. So we should just do 2 weeks.
No, it's 250 days, man. At some point, I gotta put a stop to, that's why, or it's ballooning out of control, man. It's 100 days. I mean, I'll pick a day next week. I'll set it for bond forfeiture. If he's not here next week, then
You got it. Thank you.
but no, Friday, Thursday.
Yeah.
It's SFBF.
Yeah.
All right, Justin, coming up.
Mr. Robinson, Judge, so two.
Oh, hold on a second. No. Are you ready to go on the record?
She was, sorry.
Sorry.
Oh, I think that, but we gotta add on.
Okay. But I'm ready.
All right, guys, we're going on the record. Please, no talking. What's your line?
That's Robinson.
Okay, we're on the record in cause number 2596699, the state of Texas versus Brent Robertson. Guys, if I can please have you announce yourselves for purposes of the record.
David Sharp for the state.
Fernando Batiste on behalf of the state.
Preston Harris for Mr. Robinson.
Today's date is August 18th, 2026. It's approximately 10:22 in the morning. Mr. Robertson, will you please come up? We are set for trial today in this case, and it's come to my attention that the defendant now has another bond violation. Floor is yours.
This is the one that we got like last week, right?
Correct, but there was a bond violation from 2/26/26 as well.
Oh, I don't remember that. So yes, he doesn't have a driver's license right now. He doesn't have a vehicle. On July 28th, from my understanding, he has a daily text message he gets from pretrial. He came up for a UA on that day and he wasn't able to get transportation down. I didn't see this until I think the court responded in the beginning of August and said we would address it today. He went and did a UA today with pretrial. My understanding is it came back negative, but speaking with him on the 28th, he just could not get a ride and I don't know what happened the next
But
day.
you can take an Uber, you can take a bus, you can take the Dodge Patas. There are many other ways. You can phone a friend. There are many other ways that you can get it, but I cannot continue to just hear it's a second violation. He does what he wants to do. When it comes time for us to enforce our bond conditions.
I don't know what the one in February was, but.
He didn't get a device like he was supposed to. That was the device. And
Still has the device.
I understand that he has the device,
And
Mr.
he's
Harris.
not using alcohol, he's not using drugs. The scrams on him constantly, checking for alcohol. I don't think there's been any violations on that. He came in today, he did the UA, he's negative. I think he's following your bond conditions.
But he's not. He was supposed to take a test on 7/28, not 8:18 when he wants to take a test. Therein lies the problem.
I understand, but he's not showing that he's out there doing anything that's a danger to the community. He's come to court when he's required to. I'm not seeing.
How do I know that? You're saying he's not out there doing, I mean, my concern is that you abide by bond conditions, and he didn't the first time out of benefit of the doubt for you guys. And it was a big one because he failed to get an interlock, which we normally do more drastic measures. I acquiesced and I didn't revoke the bond. But Justin, I can't continue to enable people, because if I have bond conditions on someone and they decide to do whatever they want to do when they want to do it and fail to comply, then the bond conditions really have no teeth.
Judge, I completely understand what you're saying. If he was accused of like actually doing something, like if he was.
He is. He's actually accused of not showing up for a drug test when he was scheduled.
Right, so the way I see this is, he's accused of not doing something, but he's not actively doing anything that places the community in danger, or that shows that he's, not coming to court when he's required to. He's got the alcohol monitor on. There's no allegations of drugs in this case whatsoever. The allegation of alcohol. He's got the alcohol monitor on. He's not drinking. He hasn't had any positives that I've heard from pretrial or anyone.
He's known for over a week that he has to be here. So
I called him the day that you said that you.
I understand.
Arrested on the 18th, and I let him know, we're going to be coming in front of you. We've talked about that and been preparing for the trial. But he's not using alcohol. Is negative on the test today. I don't have any reason to think he would have been positive on the 28th.
I don't know what I'm going to do. Just take a seat for me. Do not leave, Mr. Robertson. I don't know, but I got a jury waiting, and I don't want to keep them waiting for long. And this discourse will just keep going, and it'll keep going. And I don't know.
If the court thinks that he's using drugs and you want to monitor that more, and in addition to the alcohol monitoring, could we just set him on regular drug tests so that way he can make arrangements for a ride on a regular basis, rather than every morning finding out he has to now scramble to find a way to get downtown?
Careful what you wish for.
Well, he's not working right now. He's willing to do that.
Okay. Every Monday and Thursday, you got to come back for drug testing then. Okay, we'll modify the conditions.
Twice a week.
Nope, this isn't a negotiation. You're this close to going into jail, Mr. Robertson.
We're just not having problems getting down here now, so 2 weeks, twice a week.
Bond conditions are bond conditions. You're the one that picked up the case. We treat every single person the same way, This is a second bond violation. Normally.
What violation are you?
Stop. I'm not going to argue with you. I'm acquiescing to your lawyer yet again. Do you understand? This baby has way too much drama. So I'm going to roll you until next week, and we're going to go to trial. But it's way too much drama. Go ahead, take your seat. We'll modify your bond conditions, Mr. Robinson.
What's the trial date?
I don't know yet. Let me figure it out, because I've got another. How many trial settings do we have next week? 12 trial settings next week. So I don't know. I had to see how old this case is, and then I've got others that are, so maybe 2 weeks. I don't know. Oh, just. All right. Huh?
First or 15th.
What day do you want? 1st or the 15th? Or let's do the 1st.
Okay.
All right. Okay, Justin. Off the record.
So we can reset to the first, September 1st? Okay.
So the trial settings for the first, and then.
Yes, ma'am.
Time every Monday and Thursday is probably to 6.
Mr. Sturgeon, do you want to talk? I'm about to bring a jury in. Oh, okay.
Thank you, those.
Rachel, text me who you have, please. Chat me who you have.
Yes, Judge.
And then after this, can we bring the jury in?
Yes, sir.
Okay. All right. Mr. Bowers, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 10 days in jail with credit for the 8 days that you have done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you can never change this or undo this. You understand? Is this what you want to do? How do you plead to the offense of driving on a suspended license?
Yes.
Are you guilty of this offense?
Yeah.
Okay. Are you appointed? Because I don't see anyone
That is
retained
correct.
or anyone.
He needs to get a phone out and so he understands.
So I,
He's not even appointed.
Don't generate it right now.
Okay. All right. Mr. Bowers, I'm going to find you guilty. I'll follow the agreement, send you to it. Good luck to you, sir. Okay. Please don't leave. Mr. Evans,
okay.
I need you to sign the form, please. Okay. All right. Bring the jury in, please. Oh, come on up. Come on up. Karina, are you ready? Okay.
We wanted to, we could, or I guess, objection from the record about one of the state slides and either ruling on that.
Okay, sure. Shh. We are about to go on the record. Please do not talk. If you need to, please go outside. Are you ready, Ramona? Okay. We are on the record in cause number 257-968-9698. The state of Texas versus Hector Zaragoza. Guys, or let me see, it's 8/18/26, 10:30 in the morning. Would you guys please announce yourselves for purpose of the record with the state going first?
Karina Batista on behalf of the state.
Are you going to be participating in the trial?
No.
Okay, but we do have,
Yes, I will be Shantia Shah on behalf of the state as well.
okay,
And Malachi Ledbetter for the defense.
Definitely be the of the defense as well.
John Paul Cedillo, CEDILL for the defense.
okay. So we are about to bring the jury in. However, you have a issue, Mr.
Yes.
Ledbetter.
Your, one of the state slides, they have, it says, what are some common signs of intoxication, and then leads into how does tolerance affect signs of intoxication? The defense would object to the second statement, because we believe that we object to 403 and 404, that's not relevant. I'll attack 401 first, because we see many DWI trials, it's highly unlikely that anyone's going to come testify for the jury about them knowing Mr. Zaragoza, how he drinks, how much he can drink, and et cetera. So we would argue that that statement will then lead into 403. Its probative value is outweighed by its prejudicial effect, because voir diring on this statement specifically will ask the jury to create inferences about evidence that they're most likely not going to see and will require an expert testimony. So we believe that it creates an unfair inference against Mr. Zaragoza if they're voir dire, depending on the scope of that question or tolerance.
So Judge, this is a very common question with DWI and voir dires with regards to tolerance. Sometimes they have different actors or example hypotheticals in regards to someone that is really big, drinks all the time, or Uncle Joe that drinks all the time and how they appear intoxicated. This goes to show the jury to get their questions and have them talking about tolerance and have them talking about although these are some common signs, not everyone will display these signs. And just having that to teach them the law and that it's not required. And we also talked about right before that.
But there's no law with,
Well, Judge, that's why I go into talking about, this is why we have 3 different ways of proving my question. My slide before that talks about the 3 ways of proving intoxication.
Sure.
Faculties, physical faculties. So talking about tolerance, I would go into, this is why we have 3 different ways of proving it. Someone may not show signs of intoxication, but they're above the legal limit. Someone may show more signs of intoxication, but they're below the legal limit. And as the court knows, there's usually experts from the blood tests.
yeah, and you can talk about that, but why do you have to mention tolerance though?
John, it goes to tolerance. It goes to if someone is used to drinking all the time, that they may not display.
But how do you know about that?
But Judge, maybe we'll have an expert testify to that. Usually our blood or our case reviewer usually talks about.
But we're talking about tolerance in general, but how do you attribute it to the defendant?
Well, we don't specifically go, during board hour, we're not allowed to talk about case specific, Judge. This is
Sure.
why we just talk about in general, right? We talk about what.
So I don't think, just don't, please.
Okay, Judge, we've done it all the time, but if the court doesn't.
Yeah, just for now. And then if you're able to somehow in the trial get information on it, or then by all means, but please. All right, I'll sustain it just on that.
Thanks, Judge. That's all I need.
All right. Okay, are you ready? All right,
Thanks, Judge.
thanks. Take a seat, sir.
It was fun.
Yes.
Real quick. Yeah.
He is an old dude, a lot, but he's still evaluating this. I don't really want to plead until we found him, and they said, we will go to the Sunday next week.
Sure.
Myself. Thank you.
Ms. Reingold,
Yes, Judge.
on lead, you just want to reset?
It was set for bail review. He's at 5,001. I'd ask that it be reduced to 2,000. He makes about 600 a month.
I'm not going to reduce it to 2,000.
All right, for the jury.
I'll reduce it to 2,501.
Okay, thank you, Judge. May be excused.
Okay. Everybody ready? All right. Good morning, everybody. Please be seated. Good morning, everybody. Welcome to County Criminal Court Outlaw number 5. We are but one of 16 misdemeanor courts in here in Harris County. My name is David Fleischer. I'm the judge in this court. And I'm going to talk to you as if you guys don't know anything. I've never met you before. I don't know where you're from. I don't know what kind of experience you have within the criminal justice system. So let's take it from the top. There are 22 district courts, 16 county courts, and a whole host of municipal and JP courts. Does anybody know what the difference is between all three? Anyone? Okay. So there are two types of cases that one can pick up in Texas, either criminal or civil. Now, within the criminal realm, there are subdivisions in different classes, and there are felonies, and then there are misdemeanors. What's the difference? Well, the difference is how much time you are facing. If you are facing a year and above, then, and you pick up a criminal case, then you are facing a potential felony charge. Anything a year and under, you're facing a misdemeanor case. Now, within those two, there are subclasses of each. We're in a misdemeanor court. We're not going to talk about the felony courts. It may be a little bit more exciting, but we just don't have time, and I know that your time is valuable. So within the misdemeanor realm, there are three types of misdemeanors: A, B, and C. A is the worst of the lot, where you're facing up to a year in jail and or a $4,000 fine. B is the middle of the road, where you're facing up to 180 days and or a $2,000 fine. And then you have Class C, which is what would venture a guess all of you are familiar with. You get pulled over for speeding. You get pulled over for not wearing a seatbelt. You get into an accident and they give you a ticket for failure to maintain speed or causing an accident. Those are Class C misdemeanors, and they're only punishable by up to a $500 fine. Now, in this building here, we only do Class A and B misdemeanors and felony cases. If you go out all over the city, you may see just of the pieces in over here, over there, the Lubbock court, the municipal court over there in Lubbock. All those, depending on where you get your ticket, you may land in a JP all the way on Derry Ashford, all the way to perhaps Clear Lake, because Harris County is so darn huge. Now, thank you so much for coming. We, everyone here, really appreciate that you came and are part of our jury service today. We are essential for running, or you guys are essential for running an effective society. Without a jury, it would be complete and utter chaos everywhere. And the really sad thing about it is that in a city of about 3 million, 2 to 3 million people, 5% of people who are called for jury service actually show up. The numbers are absolutely abysmal, and but it is what it is. You know, so many people have better things to do. They've got work they can't take care of. So pat yourselves on the back for doing your civic duty. We really, really do appreciate it. We have two sets of parties here. I'm about to bring them up, or I'm about to have them stand up to introduce them. I'd like to see whether any of you guys know who the players are in the game. State, would you please announce yourselves for the jury?
Good morning, everyone. My name is Karina Batista, and alongside me, I have our intern.
Good morning, everyone. My name is Dan Sharp. I'm an intern with the state.
And I'll be having Shantia Shaw, another assistant district attorney, helping out.
Does anybody recognize them? Anyone? Okay, you may be seated. And defense, guys, would you please announce yourselves?
Good morning, everyone. My name is Stephanie Mendez for the defense.
And my name is Malachi Ledbetter. I represent Mr. Zaragoza.
Good morning, y'all. John Calcidio.
All right. Anybody recognize them? Okay, great. You may be seated. I think it's important that you guys get to know all the players. I don't think anyone here disagrees with the law. I think people have a big disagreement how it's applied, why it's applied, and this is why we have jury trials. We take 6 to 7 independent people who don't know each other, never met each other, give you a specific fact pattern, and ask you to make a decision. We are not asking you to split the atom. No one is asking you to do science. You're not here to do Pythagoras theorem. It's not hard. All we want from you is to use common sense and make a judgment call at the end. You guys are judge the believability of the witnesses, of the evidence. And I know each of you are old enough that when you listen to someone speak, I mean, how many people have you spoken to in this lifetime? Thousands of people. You're now well-versed enough that you will understand when you listen to someone, whether they're in outer space or whether they know what they're talking about. That's what we're asking you to do. Just listen and make a judgment call at the end. Look at the evidence, and then really, that's all. Now, the questions asked by the lawyers, they're going to try to get to know you. They want to know, do you have any prior, we're going today on a DWI. I know that I would venture a guess that a lot of you have probably have someone had a contact with either a DWI, had an experience with a DWI. But at the end of the day, all we're asking you to do is listen and make a judgment call. Please leave any outside experiences at the door. It's, we really just can't function without you guys. I anticipate this trial will be at least 2 to 3 days. We will start the trial today with voir dire. We will pick back up on Thursday and continue on and try to finish up on that day. Is there anyone who cannot be here Thursday for any reason whatsoever, or perhaps Friday? Anyone? Does everybody? Shoot.
Elementary teachers starting the school year, is that?
It's up to you. So what we would do is we're just going to pick today. I'm going to let you guys go home, and then we'll start back testimony on Thursday. So you tell me if yay or nay. I know how school is important, especially for the little ones. I've got a 4-year-old, and go to school, go. So you tell me, and we can talk later if you'd like as well. Okay. Does anyone, and one important thing, when you're answering questions, please raise up your placards so we know what juror you are. Your juror number, is it 1, 2, 3, 4, 5, 6, 7, 8, 9? Okay, juror number 9. Does everybody here speak and understand English? Is there anyone that does not speak or understand? It's okay. Believe it or not, we have impaneled jurors before. They don't say anything, and then we get them here. We start trial, and I don't. So please, anyone. All right. So I'm going to give each side about 20 minutes to do voir dire. They're going to ask you just a whole host of questions. And we'll go from there. All right. Ready, State?
Yes, sir.
Okay. Yeah.
Nice.
Good morning, everyone.
And ask for.
My name is Karina Batista. On behalf of the state, I'm going to have my co-counsel Shantia Shaw eventually join me for the rest of the trial. So the purpose of our dire, this is the only time we get to talk to you. Okay, we will not be able to change your opinion in the next 30 minutes that I get to speak with you. We just want to kind of explain what the law is and see your opinions in regards to the law. Now, the biggest thing is whether or not you consciously can follow that law. Okay? As the judge mentioned, we're here for a DWI offense. And the elements that I have to prove to you, and you do not have to memorize it, anything that is law will be given to you at the end of trial. But what we have to prove to you is these elements. That the incident occurred around August 23rd, 2025 in Harris County, Texas. Who the defendant is, have committed a crime, unlawfully operated a motor vehicle in a public place while intoxicated. Okay. Does anyone know why it is important for me to prove Harris County, Texas?
Venue being appropriate.
Venue, that is correct. So I don't prove, and that was juror number
19.
So if I don't prove Harris County, Texas, what would your verdict be? There's guilty and not guilty. Not guilty, right? I have to prove each and every element to you beyond a reasonable doubt, and I'm trying to get to what that means in a little bit. But each element is important. Each element is something that I have to prove to you in order to prove my case. Another additional element that I have to prove in this specific case is whether or not the blood alcohol concentration was at least 0.15 at the time analysis was performed. And again, you'll get the law and what that means. So I want to first talk about defendant rights, okay? Who here has ever heard the presumption of innocence? Anyone want to raise their card? In journal number 35, can you explain what that is?
It means that as the defendant is getting there, he's presumed innocent, and the prosecution has to prove that he's guilty.
Correct. So right now, it's usually you are innocent unless proven guilty, what a lot of people say, right? Right now, have any of you heard any evidence that I have presented to you? Okay, and now we know what the charge is. Has anyone here gotten a traffic ticket? Many people, right? Okay, so just thinking on jury number 6, what was your traffic ticket? Speeding, right? And when you got that traffic ticket, what did the officer say to you, if you remember?
Stop you because you were driving such that.
Okay, and they give you that ticket and they tell you usually have the speed that you were going, right? When you have to go to court, if you're gonna fight it, or what the fee's going to be, right? It's the same just by that ticket that you were guilty. Right? You're not admitting to guilt by taking that ticket, right? It's just giving you notice of what you are being charged. Okay, now, if you were, have you ever fought a traffic ticket? Has anybody ever fought a traffic ticket? No? Okay, so if you go to fight a traffic ticket, right? Or let's say you're hoping that the officer doesn't show up, which is what most people do, right? You go fight a traffic ticket, and what would you expect him to show you in order to prove that you were speeding? You want some proof, right? Some evidence. So, when in a speeding case, what type of evidence would you expect to see?
His radar markers.
Yes, some way, how do you know what speed I was going, right? So you want some evidence. So, but I'm saying that the charge is right now a DWI, we're providing notice of what we, the state, believe the defendant has committed this crime. Okay, at no point is that evidence of his guilt. It's just saying, we believe that you were driving while intoxicated. This is your notice of what we are charging you. This is your traffic ticket. Okay, now my job is to prove beyond a reasonable doubt that you have committed this offense. Now, who here, just based on knowing what the offense is, cannot presume him innocent at this time? Seeing no hands, everyone here is gonna wait to hear the evidence. Everyone, if you hear their hand, yes, okay. Now, who here has heard the Fifth Amendment right to remain silent? Yeah, juror number 2, what is it? Yeah, so you have a right to remain silent, anything you say can will be used against you, right? So if you have the right to remain silent, who here needs to hear from the defendant in order to find him guilty? Needs to hear from him, needs him to testify, needs him to stand up there. Do you need to hear from him?
Yeah.
So if he has a right to remain silent, okay, he does not have to say anything.
Right.
Okay, if he decides that he does not want to testify, I cannot force him to testify. But we hold that against him if he decides to remain silent.
No.
Now, that's his right, right? That's his right. Defendants have rights, they do not have burdens, they don't have to prove anything, okay, they just have to assert their right to remain silent. Is there anyone here that would hold his Fifth Amendment right against it for remaining silent? I see a lot of you do not fight that traffic ticket, right? So if you decide to not fight that traffic ticket, I'm gonna pay for it. Who feels like if I'm not guilty, I'm going to talk, I'm going to say I'm not guilty. Okay. So for intoxication, I think the other elements are pretty self-explanatory, right? The date that the crime occurred, where it occurred, who the person is, operating a motor vehicle. So majority of the time, what is mostly contested is intoxication, right? So the law says that we have different ways of proving intoxication. And one of those is by saying not having the normal use of mental faculties or not having the normal use of physical faculties. Actually, this not, sorry guys. How's that? Okay. So not having the use of their physical faculties or having a blood alcohol concentration of 0.08 or higher. Okay, so there's multiple different ways of proving intoxication, and I also have to show that it was due to the introduction of alcohol and or drugs or a combination of both, okay? So does anyone here can provide me with an example of mental faculties? Slurred speech, okay, juror number one, anything about physical faculties?
Unable to say your name.
Okay, juror number seven, unable to maintain your lane, okay, and why is this thing important when you're operating a motor vehicle? Correct, juror number seven, and when you're driving a motor vehicle, what are some things that you're paying attention to? Surroundings, juror number two, the road, right? If people driving, juror number four. I got you. Okay, people around, so it's like a divided task, right? You're looking at your rearview mirror, you're looking at your side mirror, you're making sure that you're going to the speed limit and, making sure you're not too close to the car in front of you, right? So that's why it's important for people to have their use of their mental faculties, their judgment, the response time, right, to braking and accelerating, physical faculties for balance, right? We talked about also possessions like eyesight or blurry vision and things like that, right? And then, or above a point of 8. Now, a lot of people, when they see a blood or DWI, they expect to see a number. Okay, but does the law, based on what you're seeing here, require me to show you a number? No, right? Okay, is there anyone here that feels like if I do not have a number, I cannot come back guilty? Juror number 9.
What other proof would you really have?
Well, I would have to show you one of the other two, right? Okay, so in juror number 9, have you ever been to a party? Have you ever seen anyone intoxicated?
Yes.
Okay, so what are some common signs of intoxication?
First speech, just body.
And when you saw this person's intoxicated, did you have a breathalyzer with you?
No.
Did you know what their blood alcohol concentration was? So how would you tell that they were intoxicated?
Just my observation.
Right, based on your observation, right? And when you get close to these people that you believe are intoxicated, can you smell anything? What do you normally smell? Right, some form of alcohol, right? So that's why the law says that if you have other proofs of intoxication, such as, the slurred speech or balancing or things like that, then you would be able to show, and we showed you that it was based on introduction of alcohol or drugs, that is one of the ways that we can prove intoxication. Does that make sense? Would you still require a number? Maybe. So, we are about to get on a plane and I am your pilot. And you asked me, are you gonna get me there safe? And I tell you, maybe. Are you gonna feel about getting on that plane? And I'm there. So that is why we ask you for yes or no, answers, right? We wanna make sure that you understand what we're saying, what the law is, and that you can follow the law. And we get it, right? Some people are like, I need to know what that number is, right? So how would you feel if you do not have a number?
I think I would like to know the number.
You would need to know the number. Would you like? So want and
yes,
need.
Yes,
You want the number. You need the number.
I need the number.
Okay, thank you so much. And that's juror number 9. Does anyone else feel that way? That without the number, even if I show you intoxication based on mental faculties or physical faculties, if you do not have that number, you will not be able to find the defendant guilty. And that's juror number 2. Okay, juror number 3, juror number 6, juror number 15, juror number 17, juror number 12. Are you raising your hand? Juror number 22, you have a question?
Kind of would like to see.
You would like to see it, right? I think we all want to see it, right? I think we all would love to see the number. And I'm not saying that you're not going to, right? This is just general conversations. But the law does not require a number, right? So if I prove to you, so I'm from Florida, right? And from Florida, we have what is called double refusals. So normally when you hear about a DWI, what do you expect them to do when an officer is doing investigation for DWIs?
I can't hear her. What is she saying? Say it again. Test how they walk in, they can get out and walk and. I can't hear her.
So it's not how they're walking, and test how they're walking, they usually have a breathalyzer, right? So like standard field sobriety test, how they're walking, how they do that, right? But let's say I'm like, I'm not gonna do that. Okay, and then they're like, okay, let's do the breathalyzer test, and they say, I'm gonna do that. So what signs of intoxication that you have seen maybe at a party or anything like that, would you expect to see? We talked about the stir speech, we talked about the balance, right? Without doing the walking test, but you may see someone like swaying, right? You may see someone having that slur speech. If you believe, and again, you have to believe it beyond a reasonable doubt, that someone is intoxicated or has their normal use of mental faculties impaired or their physical faculties impaired, you have to believe it. So if you believe that beyond a reasonable doubt, and we have to admit each and every element on that without the number, would you still require a number?
No, if they were talking crazy and swearing, no.
And again, you would have to believe it beyond a reasonable doubt, right? That I proved it by mental faculty or physical faculty. Okay, and another thing is, when you're back there, you don't all have to agree on which one we have proven, right? Some of you could be like, I believe that it was due to mental faculties, I believe his physical faculties were impaired. Or, you know, let's say, again, you don't have a number, we're gonna go based on those, because once you have the number, then it's completely different, right? So who here, after hearing your number 22, still feels that way, still feels that they need to have a number?
Yeah, ladies and gentlemen, sorry, Karina, you know, all these things that you have now, everybody wants to quantify everything. It's ridiculous. You want, but we can't. Can you imagine what it was like back in the 1980s and 70s for DWIs? All that we have now, it's all new. And with the advent of technology and with what's going on now and with everything, I mean, you can never anticipate what's going to happen next. What's the new thing going to happen? What's a new test? What's a new this? What's a new? So because of that, the law requires that you don't hold the state or the defense to an additional burden by requiring something of them. Back 20 years ago, we didn't have blood tests. Back 30 years ago, you didn't have breath tests. You used common sense, any evidence that they had out there, and that's what goes with the trial. So what we're asking you now is don't make anyone's burden more difficult, okay? Sorry.
So after hearing the judge and after hearing what we talk about, you know, the common sense, right? You have to use your common sense. Who here is still going to require a number, even though they have to get intoxication, either based on normal faculties or physical faculties, beyond a reasonable doubt. Everyone's agreeing? Yes, number 2.
I understand what y'all said. And, but unless, it's kind of hard to say, because I work with a controller,
Okay.
the shift work, the teach, the English, you make all that. To me, it seems like the guy, if he's fatigued, but if I don't smell it or see it, he can still walk. It's just, you know, I learned it through the people. And I'm not saying that, okay, if I don't smell it, that's what I'm.
I understand, so like, I mean, there's
I'm
no
not-
signs.
I'm not-
Yeah,
That's not another, because I understand what the
Yeah.
law and all that is, and I know what kind of issues they got with that. I'm just saying that that's the only way I have to smell it.
so, you know, there's signs that have said like, you know, drowsy driving is similar to drunk driving, right? I completely understand that. So then what I'm saying is, like, I have to prove to you with evidence, right? That this is due to introduction of alcohol and or drugs, right? So part of the things that you might hear throughout trial or evidence that you might see, right, is that there was alcohol involved, right? And
Well, if I see that there's alcohol, yes, I do. Sure.
yeah, so that's, you know, those are part of the elements that I have to prove. I have to prove that alcohol or drugs were involved, right? So, and part of your job as the jurors is to judge the credibility of that evidence, right? You have to determine whether or not you believe that evidence. So obviously, you were not there when this happened, otherwise you wouldn't be here, right? So you have to go based on the evidence. So let's say you would expect a police officer, right? And the police officer might say, I smelled alcohol, or I noticed, I found drugs, or something like that, right? To show you signs of intoxication, and you find that to be credible, you believe that.
Right.
Beyond reasonable doubt. Would you still need that number if you believe that his impairment is based on the introduction of alcohol or the evidence that you saw?
Yeah.
Do you still need that number? Okay, thank you. Anybody else? Anybody else still feel like I need that number after all that? Juror number 16, thank you so much for that. Okay. So we talked about our burden, right? And our burden is beyond reasonable doubt. And this is the same burden as when we have a traffic ticket, right? Any type of criminal case. We have to prove our case beyond reasonable doubt. Now, this doesn't show beyond all doubt, right? So if you knew something beyond all that, what would you be? You would be sure, you would be a witness, right? And do you have an issue with not knowing everything during number 19?
No.
Because we would have to be there to know for a fact, right? We would have to see when drinking, we would have to see all these things. So what the law says is, if we're not there because we're not witnesses, what is the lower thing right below that we can do, beyond a reasonable doubt, right? We all know that anything in this world is possible, right? But does the evidence support it to be reasonable? So when we have our elements, we say, do you have a doubt? Is it reasonable? And does it go to one of the elements of the crime that we have to show to you? Okay, so is there, in regards to like for the drowsiness, right? Do I have a doubt? Is it reasonable? And does it go to one of the elements of maybe potentially intoxication? So if I don't have that introduction of smell of alcohol or something like that, would I have a doubt that this was alcohol related? Or if there's evidence that they were working on that, would I have a doubt that it's not drowsiness or alcohol? Okay, so you can still have some doubt and still find the defendant guilty, but as long as that doubt is not towards one of the elements of the crime. Does that make sense? Okay. Pretty much what it says, if there's no definition, you will not find that in a jury charge, but it doesn't mean beyond all doubt or 100% certainty. It's something we do every single day. It's a common sense standard. So that's why we say, use your common sense, okay? You do not leave that outside. You do not all go to law school, right? You're all people of my peers, like they say, we want a jury of our peers to judge us and to be able to sit in there in the jury box and judge the evidence that we present, okay? One of the examples that we use a lot beyond a reasonable doubt is puzzles, right? Because who here likes to do puzzles? Okay, figure number 6. Okay, and when you do your puzzle, are you always looking at the picture to know what it is? Or have you ever done a blind
I look
puzzle?
at it.
Yeah.
I look at it, yeah.
And you just start building it, right?
Thank you.
So with this, let's say I have to prove to you beyond a reasonable doubt that there's 2 giraffes in this puzzle. Have I proven that to you? No, right? Okay. What about here? Does anyone still have a reasonable doubt? The 2 giraffes? No? Okay. What if there's 3 giraffes? Would you have a reasonable doubt that I have to win my case about 2 giraffes? No, right? But at least I have to do 2 giraffes. If there's more, that's different, right? I can prove to you a consultation all 3 ways, mental, physical, and emotional. Right? There's more, but the law only requires 1. So as long as I meet my element of intoxication, as long as I meet my elements of 2 giraffes, it doesn't matter if there's a third one hidden down there. Does that make sense? Okay. So the evidence has to support the facts. Now, if there's evidence that, let's say, one of these giraffes did not exist, then that's some reasonable doubt to the elements. Does that make sense? Okay, or if you get some additional elements to show you otherwise. So what type of evidence do you expect to see in the DWI? We talked about potentially drug tests or blood tests or things like that, right? We talked about some signs of intoxication. Is there anything else that you would expect to see in a case like this? Video evidence, jury number 7, okay, like body worn camera maybe, right? So what are some reasons why body worn camera may not come into evidence? Anyone else? Is any, sorry?
Malfunction.
Malfunction, that's jury number 19, number 9. It's not on, right? I know we're supposed to have them on. Who here is from Deer Park? Jury number 3, jury number 1, jury number 34. Do you know that Deer Park officers, some of them don't have body worn cameras? Yeah, jury number 3 shaking his head, right? They have dash cams. So what about when body worn cameras did not exist? Right? There was those days back in the day, right? Who here has ever heard of the objection of hearsay? Jury number 3, what is it?
It's maybe you say something that it's
Yeah, like statements outside of court that somebody else said, right? So there might be some like testimony or a witness, right? Let's say that they're not coming here to testify, but a witness is present in the body worn camera. Those are statements that may not come in. So if the officer is the one wearing the body worn camera, what do you think will be the best evidence for me to bring? The officer, right? The testimony. I want you to know that testimony is evidence, right? The same thing with offense reports, right? Offense reports are usually what? Anyone ever seen an offense report before? Yeah. Okay, so has everyone ever reported a crime report? Yes, and what would you get when you report a report, right, or a report number or something like that, talks about what's the reporting. And usually who writes that report? An officer, so again, who would be the best person to testify about that report? The officer, right, and you get to judge his credibility. Now, I'm not saying you may not see one with correction, right, I'm not saying, all the report really comes in. But those are just things that you may not get to see during trial, and we just want to get your idea in regards to that. And like we talked about, you are the ones that judge the credibility of the witnesses. You are the ones that get to determine whether or not they're saying the truth. So in regards to law enforcement, has there ever been anyone that has had a bad experience with law enforcement? That'd be like, no matter which officer, even if it's not the same, that's journal number 30, thank you. No matter which officer comes in, even if it's not the same officer, journal number 30, would you hold that against them, your bad experience with the law enforcement officer?
I probably have to think
You have.
it was a personal
It
experience.
was a personal experience, okay. And knowing that whether or not it was the same officer that had ever done anything to you, not connected to you in any way, and you have no idea, before the officer even talks, would you hold that against him, or would you wait to hear what the officer has to say? Okay, and that's what we ask you to do for any witnesses that come up there, right? We don't want you to judge them based on their careers or what they do until you hear them speak, okay? Someone can walk in here with a police uniform, and when I ask them, what is your job? They can say, oh, I'm a stripper, I'm going to the bachelor party. Does that make sense? So we want you to wait to hear what they have to say. We want you to wait to see what they have to provide, and whether or not you find them credible. So Judge talked about this a little bit about DWI arrests, and if you've ever been charged or know someone that has been charged with DWI. Is there anyone here that based on that experience does not feel that they can be fair and impartial in a case like this? Juror number 6. Okay, was it you or someone you know?
Someone I know.
Okay, and based on that experience, do you feel like you will hold that against the state or the defense?
Against the things.
Against the defense, okay. And based on experience, you're saying you cannot put that personal experience to the side, and listen to the evidence presented in this case? No, well, thank you so much, juror number 6. Anybody else? Okay, juror number 16. Okay, was it you or someone you know? Somebody. And based on that experience, do you feel like you will hold it against the state or the defense? Okay, and knowing that it has nothing connected to what your personal experience is, you know nothing about this case yet, you still hold it against it. Yes. I wouldn't be able to be impartial. Thank you so much for your honesty.
3 minutes.
Feel like that? Okay. Now, before I stop, I just want to talk about, there's a lot of mention usually in regards to drinking and driving, right? Now, is it illegal to have a drink and drive? Yes, right? But that's not what the law is, as you saw, right? The law says that you have to be intoxicated, right? So that's why there's parking lots in the bars, or there's parking lots in the restaurants. Is there anyone here that if you hear that the person had one drink and got behind the wheel with no showing signs of intoxication, not above the BAC, will still hold that one drink against them? No. Would you hold me to my burden and make sure I prove my case beyond reasonable doubt? Yes. Okay. Well, thank you so much. Anything that I missed? Any questions before I sit down? All right. Thank you, everyone. Have a wonderful day.
Okay, thank you.
Okay, I have a couple questions. One of the benefits of clean second is that we get to review your information a little more, so I reviewed some of your cards and have a little bit of information. Number 10, what kind of work do you do? Oh, like moving in. I can't. Real hard there. I can't, what was your question? I can't do. What kind of work do you do? Okay.
Administrative setback.
Administrative. For carpenters?
Well, carpenter.
Number 16. Number 16, you work for the city. Boy. That's correct, right? And number 22. Right. You listed retired congratulations. What is it that you do? What is it that you do? I'm next to about it. And, I also saw that your spouse is also retired. What do you do? Give me some background. Okay, thank you for that. And, number 15, you are a, baseball scout for the Astros. Are we about to have a great season?
We're trying in the restaurant.
Okay, we had a lot of medical or people who are working in the industry. Found that very interesting, and that might be important in this case. Number 1, can you tell me a little bit more about what you do?
Yes, so I'm a manager for our chemical engineering department, so we help look at equipment, we do the maintenance and repair for the medical equipment within the hospital. So anything that's medical equipment wise, it's going to do repairs on the health.
Okay, thank you very much. Is any of that related to, machinery used in blood draw?
Some of the lab equipment, we might potentially do calibrations on or repairs.
Thank you. And number 4, you're a nurse. Okay, and so can you tell me a little bit more about your day-to-day?
I do home health, so I just go, that's what people's houses. Go repair plans.
Is your job to make sure that they don't go back to the hospital?
Yes.
Thank you. Number 20, you're a PA. What does your day-to-day look like?
I work for an internal medicine physician, just in the clinic.
Okay, do you deal with any, of the blood draw part of the work?
We have a lab.
But you're not present there, no, but, thank you. Now. What we're gonna ask you to do today is actually insanity. We're asking you to make this weighty decision. We're gonna spoon feed you this information. You can't ask any questions. You can't go out to Facebook or TikTok or wherever you get your news. You have to stick to the guidelines that we're gonna give you. And in the real world, we don't make important decisions like that. If you or a loved one was accused of a crime, would you want to know about the people that are innocent and jury? Yes, and why? I see you shaking your head.
Credibility. You gotta trust the people that are there. I think that matters.
What are the kinds of qualities that we would want in a potential juror?
Not to listen, sure that you're listening to all of it, build fast for making decisions.
And active listener, thank you. What are the things that we would want? Pardon?
Honest.
Somebody who's honest. Thank you. What could happen if we don't hear from you and you end up on the jury? What are kinds of issues that could come up down the road?
We don't know their thinking.
We don't know your previous experiences. We don't know if you have any biases, any prejudices. For example, I am in love with my pets. I believe that they're part of my family. I would never be a fair juror in an animal cruelty case. I treat them like family, and so therefore I have to ask, is there anybody who would not be a fair and impartial juror in this UBI case? 16, where you're community feels. Anybody else who did not speak that has any experiences with somebody suspected of drug involved intoxicated?
At Shell, we're committed to preparing you for her.
All right. Please, please. Number 8, do you mind telling me a little bit more about that?
It was a family member and, they were, I'm sorry, it was a family member and they were consumed drunk, where they actually was not, but it wasn't treated that way, so.
Your family member was presumed of injury. Is that? And are you saying that would affect you the way that you use evidence in this case?
Yes.
Okay, so therefore you would not be able to be fair and impartial on this trial, correct?
I probably won't. I can go in both ways, to be honest.
Okay, can I get a yes or no? No. No. Thank you very much for sharing that. Is there anybody else who feels the same way? Anybody else? So our job is to find out if you're the right person for this case. Sometimes we're not, like I said, I would not be the right juror in an animal cruelty case. I would immediately jump to conclusions, and that's what we're trying to avoid here. Now, please raise your hand if you've ever seen anybody pulled over on the side of the road and they're taken out of their vehicle. Keep your hand up if you've seen that person actually get handcuffed. Keep your hand up if you thought, man, I wonder what he's innocent of. Yes, that is not our natural instinct, that is not it, that this is not natural, that's why I'm saying what we're asking you to do here is actually unnatural, it's not normal, and that's why I need to find out if you can actually do this job that we're asking you to do. Now, you can't do what feels right, what feels good, and I will submit to you that a lot of people are well-intentioned and want to do the right thing, but their brain just doesn't work that way. And I will ask now, if you are asked to render a verdict right now, what would your verdict be? Not guilty. Not guilty. Is there anybody else who has a doubt about what their verdict should be at this point? Okay. Now, I think it's getting really important. Now, we've all heard it before in TV shows, if a cop is investigating you for I don't know, there's a cop is coming to your door and they're investigating you, it sounds like they're accusing you. What is something that we hear in movies or it's all over social media, what are attorneys advising you to do? What is that right? To remain silent. But why? Why does the right to remain silent exist? Number 22. What is?
Might say something in a different way that we happen, but they interpret it a different way.
So you're hitting why somebody would want to exercise the right to remain silent. Thank you very much. So yes, you might say something, you might be nervous, you might, you know, whatever you say may be misconstrued. There's a lot of reasons. Are there any other reasons? What do you think of another reason why you would want to exercise that right to remain silent? Correct. Now, but why? Why does it exist?
Something around the law.
So our founding fathers knew that the government has this immense power. When the government decides to accuse someone of a crime, they have investigators, police officers, forensic experts, they have prosecutors, they have virtually, all the resources, they have all the resources. And our founding fathers knew that that kind of power can be dangerous if left unchecked. So all the verdict goes to them, and this exists to protect us, not just those who are guilty, but also those who are innocent. Yes? And now, this slide is juror number 7, can you give me a word that jumps out at you when you see that picture? Wait, crossroads, and then when you're at the crossroad, you have a choice, right? Is there anyone who would hold it against our client if he decided to exercise his right to remain silent? Is there anybody who would want to hear from him? Great, thank you. One last question to hit that point. Is there anyone who would consider our client's silence for any reason? No?
Like if he's silent, he doesn't say speak.
Correct.
Because he didn't say anything, and I think he's getting that. I'll come up with you.
So you would, so let me see if I'm understanding correctly. If you didn't hear from him, if he exercised his right to remain silent, you would consider that?
Yeah.
Yes, okay.
I think it's also challenging to sit here on one side and not hear from him.
Okay, so, I'm gonna ask you a follow-up question. Would you consider his silence for any reason?
Can you restate it?
I'm sorry, say it again.
Can you restate it?
If he exercises his right to remain silent the entire trial, would you consider that his decision to remain silent for any reason at all?
Yes.
You would. Anybody else that feels that way? Thank you for sharing.
Let's see.
Okay. Now, another protection that the government, that the founding fathers, came up with for us was the burden of proof. The government has all the burden because they have all the power, all the resources, they have everything. It's another protection for us. Please raise your hand if you have kids. Please keep your hand raised if they're still minor children. Okay, how much evidence would the government need to take your children away from you? Number 31.
A lot.
All right. If you look at the chart, it's towards the very convincing. That's the burden that the government needs to take your kids away from you. Clear and convincing. And even that is not enough to convict someone. Okay, the burden of proof here is beyond a reasonable doubt. If there's any possibility that there's another reason that other than that the crime was committed, that is a reasonable doubt. Do you agree with me on that? Does anybody have any questions? Oh. Alright, guys, I don't know what that is. Okay. Is anybody here clearly convinced of what this image is? Let me ask juror number 3.
Yes.
What do you think? What do you believe that is?
Pistol with the laying next to it.
With a what?
I feel like for a magazine.
I'm gonna show you the next picture. What is it? What is it actually?
It's a pistol with the orange tip, orange boy.
It's a toy. All right. So now I'm gonna ask you some skill questions. There's 3. I'm going to ask you guys, I'm gonna call you out by number and I'm just gonna do an example. The first question is, which statement describes me better? 1, I tend to question authority, or 5, I tend to trust authority. Okay, from 1 to 5, where are you? And I'm gonna pull out your number and then just tell me what number you are, yes? Got it? So, number 1.
5.
2,
4.
3,
4.
4,
I'd say 2.
5,
3.
6, 3, 7,
2.
8, 9, 10, 11,
3.
12, 4, 13,
4.
14,
3.
15,
3.
16, 4, 17,
4.
18,
4.
19,
4.
20, 21,
3.
22,
4.
23, 4, 24,
3.
25,
3.
26,
1.
27, 2, 28,
3.
29, 4, 30, 31,
2.
32,
3.
33.
3.
Is he the last one?
2 more.
Oh, 34, 4, and 35. 3. Okay, thank you. Easy enough. Let's go to the next one. Okay, when making a group decision, One, I form my own opinion first. 5 is on the other side of the spectrum. I look to the group for direction. Right? 1,
3,
2, 3,
2,
4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 2, and 35.
2 minutes.
Okay, when I disagree with a group, 1, I usually speak up. All the way to 5 would be the opposite side of the spectrum. I usually keep it to myself. Ready? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Oh, sorry. 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. That was 3. 31, 32, 33, 34, 2, and 35. 2. Thank you guys.
Heard it?
Yeah.
Okay. All right, Lori, if you're going to come on up. I'm going to ask them first for pauses and then we'll go. Okay. Yeah, and I'm with you too. Yeah. I'm waiting on. Let me know, Ramona, please.
Ready, Judge.
You ready?
Yes.
Okay, state, do you have any for cause challenges?
First round, number 6, personal experience.
Okay, I'm going to grant that. Okay. 9. Yeah, yeah, yeah. Yeah. I think that's it with the first row. Okay.
The second one, journal number 16.
Yes.
And journal number 22.
Which one was 22? Let's see.
Six,
16, 17, 18.
The last one.
Oh, pretty cool. Okay. Yeah. Okay.
All I have is second one.
Say it again. Third
All
row.
I have is
Yeah.
second. I think the fourth day around, so we're gonna get to the journal number 26.
Okay. Well, X name. You said 23?
26.
26. Okay.
5 has a theft as well.
Which one?
Number 5, I'm sorry, I forgot to mention.
Yeah.
Was it a deferred? Was it a deferred?
benefit calculation. Judicial speaking on probation judge.
Straight? Okay, so
Question, so, disposition deferred.
this is deferred. Success?
It just says disposition deferred.
Given a J, do you have a JNS?
No, there's not there. I don't see anything about it. I didn't go look for anything like that.
What do you guys think? You okay with him on?
I would just ask for a feeding charge if we can on this one.
Yeah. Are you guys in agreement on 5? Okay, all right. So anyone else on 3rd?
I have no relation with it.
No one else? Okay. Ms. Pimentel? Do you have any for cause?
No.
No? Okay, great. So this is what we're gonna do. I usually pull an alternate as well. So each of you will get 4 parameters. Don't take long, 5 minutes. And then come back and then we'll reconcile.
And just learn the ones that are all done.
Are you ready?
Yes.
For the full cause? Yeah, we've got 6, 8, 9, 16, 22, 26.
Judge as well.
Oh, I thought you were in agreement to keep.
Yeah, no, to take it out.
Oh, we were.
They were agreeing to keep it because it was a deferred.
That's fine, yeah, that's fine. I thought we were.
Okay, so no, you're good with everything state.
Yes.
Yeah, but just to, before you go into all of our, what do you want to do here about the teacher that's going to school?
She cut, she's cut, she's number 9. No, she's 9. Yeah. Yeah. 5 minutes. Okay, all right, guys, take 5. You guys got the lists?
Yes.
I'm getting them ready right now, Judge.
Oh.
Yes, sure.
Okay, guys, so what's going on now is each of the lawyers get what's called peremptory challenges. They get to take certain people off the jury. If you answered a question wrong, you looked at them wrong, did something that they didn't like, if they get a bad feeling, there's a couple exceptions, but virtually whatever if they have a bad feeling, they can take you off, essentially. So each of them have a limited number of peremptory challenges. I'm giving them each 5 minutes to make their decision so we can get you guys out of here. Try to be as efficient as possible. For those of you who are selected, once each side has done their peremptory challenges, they'll bring up their list to our clerk. Both sides will reconcile, and we will reconcile the list. And then the first of those who have not been taken off will come and sit on the panel. For those of you who are not selected, I'm so sorry. I know that you wanted to stay. I know that you wanted to hang out with us and learn some, the funny thing is that no one ever wants to go to trial. No one wants to come to voir dire. I don't even want to be here, and I work here. But it's such a great learning experience. Every time we have a jury panel go out, they come in hating us and then they leave. Wow, that was really cool, because it is. You get to see what goes on in an everyday situation when someone is arrested, what the decision is, how they do it, why they do it. And it's a great talking point whenever you're out there going to shoes. So, for those of you who are sadly not chosen, I'm sorry. I hope that you'll come back and see us one day. And if you're further selected for any kind of a panel, please show up. We do need you. All right. All right, guys, 3 minutes, huh?
Sure.
5 minutes. 5 minutes. That's why we put some.
Yeah.
I hate listening panels. It's such. Yeah, it just, it's, it just.
I do have a question.
Shoot.
If I prefer to not miss that many days of school, and can I tell you that I prefer not to, or is that not an
I
option?
don't think you have anything to worry about. Your wish has been granted. If I had a, like Harry Potter, like my kid. Do you have a copy of information? Yeah, you want to get ready?
Yeah, I'll do
Yeah.
that.
Okay. This way. Ladies and gentlemen, when you hear your name called, please rise and come take a seat in the jury box. Okay?
Jury number 2, Daniel John Hamilton.
Those are love, right?
Jury number 3, Kyler Daniel of Zarza. Jury number 7, Derek Charles Richard. Juror number 10, Davina Garza. Juror number 11, Roberto Wallace Escobedo. Juror number 12, Tiara Nicole Marion Adeniji. Juror number 13, Lawrence Eugene Champion.
All right. Welcome, welcome. Come one, come all. All right, so ladies and gentlemen, I'm going to ask you to please rise and raise your right hand to be sworn. All of you, you each speak English, correct? And you all can be here Thursday, correct? Awesome. Okay.
You and each of you solemnly.
Oh, I'm sorry. Any objection from the state?
No, yeah.
Any objection from the defense? Okay. Sorry, now you make, I'm so sorry.
Thank you, Judge. Do you and each of you solemnly swear that in the case of the state of Texas against the defendant, you will a true verdict render according to the law and the evidence, so help you God?
All right, you may be seated. Ladies and gentlemen, you're done. Thank you so much for coming. No claps, no claps. I mean, really. We hope you'll join us one day. Our bailiffs will help you out on your way out. And thanks again for coming. Hey, defense. Defense. Just arraign and then we cut. Okay.
I understand. You know, you're right, you're open.
They moving too much?
They're okay.
Oh, shh.
Are you ready,
Wait till they go on. No. Let's wait till they shuffle out. I guess we could just go ahead and arraign, right? We can just go ahead and arraign. I think it's a big deal. Did you write down all the juror numbers? Forgot to. Okay. Can you write down in order juror numbers?
I have it.
Which one? No. Okay, are you ready? Stay.
Ready, Judge?
Okay.
In the name and by the authority of the state of Texas, comes now the undersigned Assistant District Attorney of Harris County, Texas, on behalf of the state of Texas, and presents in and to the Harris County Criminal Court at Law number 5 of Harris County, Texas, that in Harris County, Texas, Hector Zaragoza Gomez, hereafter solemnly defendant, heretofore on or about August 23rd, 2025, did then and there unlawfully operate a motor vehicle in a public place while intoxicated. It is further alleged that an analysis of the specimen of the defendant's blood showed an alcohol concentration level of at least 0.15 at the time the analysis was performed, against the peace and dignity of the state, signed by an assistant district attorney.
To which the defendant pleads. Okay, you may be seated. Ladies and gentlemen, we're done for the day. I'm going to go ahead and send you home. While you are there, please do not discuss this case with anyone. Do not do any independent research. Don't talk to yourselves about this case. We want you guys to come. We're going to meet here Thursday morning, 9 in the morning. We will promptly begin testimony. I'm going to be as sufficient as humanly possible so that we can just get you done and get you out, because I know that you're busy and I know that you don't want to spend any more time with us, and it's okay, I get it. But your deputy at Chigoin here will be your point of contact. If you have any questions, if you have any issues, if someone comes up to you, he'll be your point of contact and you can relay anything to him. Other than that, we'll see you bright and early Thursday morning. Question?
Will we be up here at what time?
9 in the morning,
They can still park in the garage?
please.
Okay.
Yeah, and then we'll give you passes at the end so that you don't,
Okay.
yeah, okay?
All right, for the jury.
Okay, guys, remember Thursday it is, okay?
Yes.
All right. Okay, guys, we're in recess. We're off the record. I have to take, you guys can be seated. I got to take care of a lot of housekeeping first. And then I guess we'll talk after that. Are you ready? Anybody, lawyers, coming up?
Here's one thing, Judge, we filed word protection since it's Thursday.
Yeah, I get it. I'll sign it for you. Don't worry about it. You know what? Why don't we do this? Why don't we, hey, let's do this because we've got so much to do right now. Let's come back tomorrow morning. Take a look at the limiting and let's argue at 9 in the morning tomorrow.
Sounds good.
Yeah. Okay. Okay. Hi. Hi.
Judge, you need Mr. Derrick back there.
No. No, Thursday.
Yeah.
For sure. Okay. Hi, Ms. Dawes.
I have a quick off jacket.
Okay.
I have to take number if you need it.
Okay, what is it?
It's 2608-032.
On Hamilton?
Yes.
Okay.
So he has to go to work in San Antonio August 19th through the 21st.
I'm okay with it. Just let them know in the event that he gets called. They just have to go to Quest.
Okay, that's it.
Yes, ma'am.
Thank you.
Okay, and we'll waive the signature.
Okay.
Okay. Anyone?
So do we have an arraignment?
What?
It came in, right before we got on the list.
Okay, you want to call him up?
Did I have Mr. Darren Williams here for arraignment?
Okay, you want to bring him up? Is this who you're talking about?
No, Judge, there's somebody.
So Judge, I was appointed to Mr. Williams, he's on the way.
What time did Mr. Williams get here?
So Judge, I was appointed to him probably 3 weeks ago when Judge Senior was on the bench. We did PC, Judge found PC, Judge granted him a PR bond, and Mr. Williams was released from custody. And I'm understanding now that he needs to be arraigned again.
Judge, just to take a second look at the conditions, that was.
Yeah, just take a second look at the conditions.
Mr. Williams, you charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. What time did you get here today?
I just got here about maybe like 5 minutes ago.
When does court start?
Lost my papers. Course was like 2 months ago prior to what it is now. So
This is not your first assault case. This is not your first time in court. What time does court start?
I don't know, sir. I lost my papers. I've been homeless.
Then let me be frank and upfront with you, Mr. Williams. I don't know who you have in this life, but if you start playing games, because I see about the other assault that it's set a 70-10. That means it was bond forfeiture after bond forfeiture after bond forfeiture. We don't play that game here. You start trying to play games, I will put you in jail. There will be no more PR bonds, and I have no problems making it 10,000, 50,000, 500,000. I've made a bond millions before. Do you understand me?
Yes.
You come at 8:30. This is not the Darren Williams show where you get to do whatever the hell you want to do. It doesn't work like that. You show up when you're ordered to show up and you have bond conditions. Break either of them, so goes the bond. You understand? Let's do PC, please.
Yes, sir. On June 16, 2026, at roughly 10 p.m. in Harris County, Texas, an officer responded to an assault call at the diversion center in Harris County. The complaining witness stated the victim was in the facility when a verbal altercation broke out between the defendant and a female staff member. The complaining witness told the defendant he would be taken care of, but he needed to calm down and stop using profanity. The defendant then threw a coffee at the complaining witness, though this coffee was cold. But then the defendant then struck the complaining witness in the nose with a right closed fist, causing pain and discomfort.
Where was this?
The diversion center, Judge.
I'm ordering you not to go back to this location. You are not allowed to go back. You're not allowed to have contact with the complaining witness in this case, and you're not allowed to have any kind of weapons whatsoever, including ammunition. If you violate these bond conditions, if you pick up a new case, into jail you go, no more PR bonds for you. Do you understand? This is not a revolving door. If you endanger my city, it's just really not going to go well for you, Mr. Williams. I have, and I'm well within my right to take you into custody. I had already revoked your bond at 5,001 now. Does he have multiple non-appearances, Victoria, or is this the first one? You know?
No, Judge. This would be the first.
Karina, do you mind finding those conditions on Mr. Williams, please?
Yes, Judge.
No weapons, no going back to the Ed Emmett Center, no contact with the complaining witness.
Mr. Duran, correct?
Yeah.
If you are late again, I will roll you to the next day until you get here at 8:30 a.m. We will make a docket notation of everything. Do you understand? You smell weed?
No, sir.
Okay, all right, come on, we'll have you sign your conditions. Don't, make sure he doesn't leave until he signs conditions.
Will do, Judge.
Okay,
Thanks, sir.
and I'll reinstate the bond.
Thank you.
Okay. I swear I smell weed. You guys smell weed? Well, just kidding.
Bottom of 10, Davis. What is she done? Davis. Oh.
She gone? Okay. She what?
She took back, but then she went.
Okay, 5,001. Adam, are you ready?
On Daniel Street?
Yeah, is she here?
If I could have just a few minutes.
Sure. Herbert. I need you to unmute. Come up, Mr. Celestino. Mr. Herbert, can you hear me?
I can hear you, Judge.
Okay, I asked him to provide proof. Did he provide any?
No, Judge. I requested proof, and it would take a week to get the records to me. He did schedule an appointment on Friday to have his car calibrated, at which time they can pull the entire records. But we're approaching today for a plea.
Oh, you're doing a plea.
Yes, Judge. The attorney didn't sign the immigration consequence.
I need you to sign one of the forms, the immigration consequence.
I'll do that right now, Judge.
Okay. Are you ready?
I see his thumbprint.
We need your thumbprint.
Right. Raise your hand. Do you solemnly swear or affirm the confirmation these documents is true?
All right, Mr. Celestino, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. What agreement have we worked out?
It's like 18 months probation, Judge.
Really? We couldn't even keep you while on bond. We were having issues. Every time you were on bond, you've had issues. And now for 18 months on paper?
Yes, sir, I'm pretty sure, since the first day I was here, I could have made at the beginning, it was different.
You're still going to be required to do the same thing. You will have to have an interlock on your car. You will, no drugs, no alcohol. You understand that you're facing a lot of time in jail. Yeah, Harriet, she can come up. Do you speak English, ma'am? Entonces, toma asiento. No puedes ayudar si no puedes contestar. Toma asiento, por favor. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You will be required to do several things, Mr. Celestino. If you fail to do them, it's very possible that a warrant gets issued. We will have a hearing to determine if you violated this agreement. If you do, you are facing 180 days in jail. Do you understand? If you don't do your classes on time, if you test positive for alcohol, if you fail to get the devices instructed, then a warrant will issue, and then we will have a hearing. Do you understand? For you to complete this successfully, you must do first a TRAS. This is an evaluation to see what conditions you may need. If they assess other conditions, you must fulfill them. A DWI repeat offender education class. 1 victim impact panel. No drugs, no illegal drugs, alcohol, random testing. You must have a guardian interlock. You have a car at home. I'm not going to trust that you're not going to drive. You must have the interlock. Do you know if he's in compliance right now with the interlock?
If I may, Judge, I think the current status is that his car hasn't been operated in probably the last month. So there's been no communication between the device and Smart Start.
Does he have a license to drive? Karina, do you mind looking if Mr. Celestino has a valid Texas driver license, please? And no breath test refusal while you're on probation.
He's not compliant because he never got the device recalibrated, so we have to bring this.
Okay, so he's got 1 week. So let's do it. In the event that he doesn't get in a week, then, well, no. I'm going to reset it a week so that he can come back and provide proof that the interlock is installed and operational. Otherwise, I guess we'll have a hearing.
That does not, he does have an ALR suspension until July 14, 2028, because he's under 21.
Okay, give him a portable device then. We'll do a portable, yeah. All right, how do you plead to the offense, sir? Guilty or not guilty? You know, every time someone looks you up, Mr. Celestino, the only, like, if you get into a car and you get pulled over, because that's what officers do, they pull you over, and they always pull you over at the absolute worst time of your life. When they see your record, they're going to see DWI, DWI. If they smell alcohol, if they smell weed, what do you think they're going to do? From now on, you are looking at a minimum of 30 days in jail. Do you understand me? I expect you to comply. If you don't, it may not go very well between us. And I already remember you and I know you, and it's not good for judges to know you. Do you understand?
Sir.
All right, waive his fees, please. All right, good luck, sir. We'll have you see the clerk. No, let's just get the, but I want to know, he's got to get it within 3 days, the portable device. All right, thank you, Mr. Abear.
Thank you, Judge. Am I excused?
Yes. Victoria, anything you want to talk? Do we have that arraignment? Okay.
Three, Austin.
Austin, come up. What time did Mr. Austin come up? Okay, I need you to document, please, come up, that this gentleman got here about 11 o'clock, 10, maybe 10:45. Yeah, what are you playing Hella Keller for? Court starts at 8:30, not at 9, not at 10:05, 11:32. We mark it down. The next time you're late, I'm gonna roll you to the next day, and I'm gonna roll it until you get here on time. You understand? You're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes. On August 10, 2026, officers were dispatched to a weapons disturbance call at a residence in Harris County, Texas. Upon arrival, they met with the first complaining witness. The first complaining witness told the officers that she was standing on her balcony when she observed the defendant park a white Kia Soul in front of her vehicle, take out a blunt object, and began striking the first complaining witness's vehicle, causing $900 worth of damage. As the officers were arriving at the apartment complex, they saw the defendant exiting the complex in a white Kia Soul, matching the description provided by the complaining witness. The officers initiated a traffic stop in a marked vehicle with emergency flashing lights and sirens. The defendant sped off and almost struck another vehicle while attempting to flee. The officers pursued the defendant for approximately 0.9 miles, reaching a top speed of 80 miles per hour until the defendant wrecked out at an intersection and rolled the vehicle over. The officers were then able to successfully detain the defendant and positively ID him with a previous government booking photo and his Texas ID card. The officers were contacted by the second complaining witness, who is the owner of the Kia Soul. The second complaining witness reported her vehicle stolen and explained to the officers that she had previously allowed the defendant to borrow her vehicle. However, the second complaining witness and the defendant had just broken up the day before this incident, and the second complaining witness informed him he could no longer use the vehicle.
So they charged him with the UUMV, evading arrest in a motor vehicle. Now we got him in here, and he has 2 prior mischiefs. One that was, Mr. Austin, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm now going to put a GPS monitor, and I'm giving you a curfew of 7 p.m. to 7 a.m. I don't want you out at night. Do you understand me? You are not to go back to this complex. You are not to go within 1,000 feet of where any of the complaining witnesses live or work, and you're not to be in possession of any weapons. You violate these conditions, I will deem you a public danger. I'm going to put you in jail, and I'm going to go bananas on your bond. Do you understand me? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset. You'll meet with Veronica for your bond conditions, and then we'll see you in 30 days.
Did you say no weapons, Joe?
Don't worry about it. He's going to be monitored so that,
Judge, was that based on?
no, he's going to be monitored. All right, good morning, Mr. Lee. I don't see Rachel.
She's going to appear via Zoom. She wasn't able to.
Oh, hold on. Maybe this is her. Yep, here she is. I've got Elena here too. She's in the room. Right. Mr. Lee, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have worked out is 10 days in jail with credit for the 4 days that you have done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You know, Mr. Lee, we don't ask much from you. We really don't. We want our streets safe. And when someone asks you not to go back, I mean, we mean it. You know, you're old enough to understand that actions have consequences. And when you pick up a criminal case, there are expectations of you. And when you don't live up to those expectations, then really, you know, or you should know, if you don't have anyone in this life that's willing to pony up even $200 to get you out of jail, if you're out there and there are shenanigans afoot, it may just not end well with you. You understand? How do you plead to this trespass? Guilty or not guilty? I'm going to find you guilty. I'll follow the agreement. You also need to understand this will now reflect as a conviction on your record. From now on, you're facing a minimum of 30 days in jail. You understand? All right. Good luck, Ms. Lee. We'll have you see the clerk. Thank you, Ms. Reingold.
Yes, thank you, Judge.
Elena.
Page 4, Judge.
Did the
I'm here,
defendant
Your Honor.
again?
Yes, Judge.
I'm here.
Okay. What are we doing with Banks?
Hold on 1 second. We brought him back to admonish him, Your Honor. Hold on 1 second.
Banks, come up.
I'm sorry. You rolled him a couple of weeks on that because it was some unusual facts in that. And this is not something that my client is wanting to plead to. And so you wanted him to come in and we rolled it.
Okay, I got it. I understand. So
I'm
you
sorry,
do
I'm
have,
just in another court. He is present.
yeah, I got, he's here.
Okay.
He's here in front of us. So you have an offer on this case, correct? Elena?
Hold on. Can you hear me, Your Honor?
Yes.
Yeah. Yes, there was an offer, the standard offer that was in there. I can't pull it up. Hold on 1 second.
So today is your plea bargain deadline. Your case is 180 days old and we need to know whether you want to set it for trial or whether you want to accept a plea bargain. It's up to you, whatever you want to do, but I want you to understand that I have enough drama in my life. I don't need any more. If you want to elect to go to jury trial, great, but we will have a jury trial. I will not accept any more plea bargain agreements after this day. Do you understand? So I'll have you guys step out. You make the decision on what you want to do. And I don't need you to make it here. If you want to set it, we'll set it today for 30 days from today. And then we'll just have a jury trial when you come back. You're facing 180 days in jail and or a $2,000 fine. Do you understand? Okay, please. You guys let me know. Do you want to talk to him first or no?
Yes, I'm just upstairs in the 184th. And
Yeah,
so,
whatever you want. Yeah, I mean, he's here.
okay, I'm just.
I'll wait for you.
Okay,
Okay.
that's fine. I'll
Thanks,
be
Elaine.
down. Thank you. Bye-bye.
Bye. Hi. Good morning. Randall?
Yes. And she's in the audience.
Page 27.
Thanks. Okay, what are we doing with Miss Randall?
We are setting the case in trial.
Miss Randall, come up. So did she not want to accept this agreement? Okay. So they have given you an offer of if you pay restitution and do an anger management class, that they would dismiss this case. Is this, you don't want to accept this plea bargain agreement? Well, it's not whether you can afford it. It's just whether you want to accept it or not. It's just, how much is restitution?
$1,100, Judge. We did provide medical bills and information about that.
Okay, so I don't know what's going on with this case, but all I know is that if you're found guilty, one of the things that we normally do is restitution, just because it's fair. I don't know what happened in this case. I have no idea. All I do know is that it's a pretty sweet deal where if, you know, it'll end up in a dismissal if that's what you want. If you don't want it to, you don't have to. but I will not accept any more plea bargain agreements after this date. Your case is 190 days old. If we set it for trial, you will go to trial kicking or screaming. I will not accept any more. You understand? Okay, you guys tell me what you want to do. Yeah, I don't need you to make a decision here, you know? It's a pretty sweet deal, but it's up to you. So why don't you guys step out and tell me what you're going to want to do? If you do want to set it for trial, we'll go 30 days from today. We will pick a jury like we did today earlier, and then we'll see what happens. Okay? All right. Thanks. Hey, do you want to go through the list? $5,001. Yes.
We're on the Saldes.
Okay, who's next? Oh, right under it, Davis.
Davis? Oh, you're both that.
Yeah, okay.
Top of 11, the lane to mark posted, W2.
5,002. Okay.
Bottom of 12.
5,003 on both. And I've already done BOs. So is it 3 or is it 2? So the 2 that are on docket today, 5,003,
The other ones are done tomorrow.
we'll wait till tomorrow on that one.
So 5,002?
3. Yeah.
Top of 21.
Okay.
All of them said they were gonna read that.
Okay, 2501.
Top of 29. I've emailed council multiple times to swing by, no response. Just had a Matt swing by for her, you just didn't today.
Okay, I guess SFPF tomorrow.
The defendant's here, just a heads up.
Don't know what to tell you. I can't do anything without a lawyer.
Yeah.
They need to reach out to her. Papa 30, I guess.
Yes, we just got the results. I'm reaching out to council to swing by.
Is that the last one?
We have a plea in the back on bond, yes. Because it's no fun. It's not because I said like, I don't have any change. It's I don't want to make a decision. No, but for that, I'm not taking, but doing it. It'll just, yes, I'm taking back to this. They set up better, they're gonna find from the height. I don't know what's funny, there's so much. Abandoned at a time.
Hi, are you ready? Here. Mr. Hurd, you're charged with burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 6 days in jail with credit for the 6 days that you have done. You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. This will now reflect as a conviction on your record, Mr. Hurd. I don't know how many you have, but at a certain point, if you continue to pick up B&Bs, you're either going to get a shotgun blast to the stomach like we've had here on multiple occasions, or they're going to enhance you to a felony. And if you have prior felony convictions, they can just continue to enhance you as the day is long. And at some point, it may be a 25 to life case. You understand? So it's probably a good idea to be very, very careful. You don't live in Montana. You live in Houston. They like their guns and they like their cars. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send you to the 6 days, give you credit for the 6. Good luck to you, sir. Thank you. Have a good day. Hey, did he just, you called him? Okay. Thanks. Did you get a hold of Mr. Harris? Did he provide a sample? And what? Oh, you made it. Wonderful. Hi. It's okay. You ready? Coming up. So your client tested positive for marijuana and was it a benzodiazepine? Does he have, did he provide any proof of scripts to you or to pretrial services? Mr. Valdez, come up.
Judge, if, before, the court makes a ruling on whether they're going to hold on suspicion, I would ask for some time to talk with the state, maybe we can come to a resolution today, if you would still entertain any plea.
I can't. I mean, you have 4 open cases, Mr. Valdez. When does it actually stop? You know, we put bond conditions on people for a reason. You know, this life is a very slippery one. And there are smart things to do, and there are things that are not smart to do. When you're on bond for 4 cases, we tell you what to do, what not to do, because what we don't want is you to get in more trouble. And we try to do everything in our power to put conditions in place to hopefully avoid any more entanglements with the law. You're on bond for 4 cases, and you've now tested positive for marijuana and a benzodiazepine. That's a problem, because obviously you are not taking us seriously. And I just don't know what else to do, but I have to put you in jail, Mr. Valdez. So I got to revoke your bond. Yeah, I'm just going to double them up. So you're now, all your bonds are 5,004. So I'm going to set them at 10,005 on all of them.
For each case.
For each case. That goes with you. Hopefully this is.
Any chance we can hold until tomorrow, bring him back?
He's going to come regardless, because every time we revoke someone's bond, they auto-populate the next business day. So, yeah. Okay, thanks.
Judge, you said 3 at the end?
No, 10,005 on each. They're at 5,004 now.
Does he have a jail?
Hey, Mr. Harris, and then Farina, I don't know if you have to do any kind of rips on the case. So just be wary that, you know, because one of them is a disorderly conduct, it's a firearm case, so.
Yes, sir.
No.
Can I stop the case?
Yeah, of course. What's the cause number?
26.
Okay.
03.
Okay.
8960.
In Washington?
But it's an occupation. He pled last week or sometime last week, and he thought he was done with the occupation. So he removed the device and everything. Right now, he's telling me he doesn't even want to do the occupation.
Hey, is she videotaping? What, she's got something flashing over there. Oh, okay. So what is
he
it?
wants to remove the occupation. I don't know the process to withdraw the occupation.
Did he file it himself?
I think he had an attorney.
He's got, the lawyer's got to do it.
Okay.
Yeah. Yeah, I'm not allowed to, we're not allowed to talk to him without the lawyer. If he had a lawyer present. Yeah.
This order. What do you think we should do? You know why that's, you know why that's on. No. Yeah, you know, they can look when they can. But even if this is not a conviction, you still have all the other side of it, right? That is not the
They submitted a violation report when he played on 8/13 because he removed the device. So I don't know if that makes a difference.
Yeah, they have to file a motion.
That is the motion.
No, that's a violation report on the ODL. They have to file a motion to revoke on the probation. If he's on probation.
He's not on probation. He was just being supervised for the ODL. So
Oh, okay. So just revoke it then. If there's a violation, revoke it. That's it.
so then the clerks would generate.
Yeah, yeah, revoke it. And he's not allowed to drive. So, but he's not on probation? Okay, all right, yeah. So, I mean, that concludes our,
Yeah. Court directed to revoke.
okay, who's the lawyer on the plea?
And because responding to my email that he's coming, he's on. He was waiting for the papers to be filed. Hey, Karina, the supervision order on Eldridge is a thumbs up to be filed.
Filing another one for. Well.
For which one?
Samantha Wells.
Oh, that must be off docket.
That one is off docket. Yeah, she's off docket for the 27th. So Eldridge.
$18 months from today. Which is the stuff today. Let it be let the Wednesday. It's actually.
You know, I started doing it, as they used to be. Yeah. Yeah. Well, I don't know if that.
All right, Adam's here.
I moved in there 2 weeks.
Yes.
Are we gonna have another plea?
Yes, it's Adam's client.
But it looks like there's another.
We're
Are you guys doing a plea or no?
doing a supervised PTI.
Okay. So is it a 6-month PTI?
Yes.
Okay, talk to me.
We've got a deal in place for Mr. Valdez. You want to do it tomorrow? It's a deferred adjudication for 2 years.
Yeah.
To get a GED, for them to get or high school diploma, because I think he's.
I think it'd be so listed tomorrow. Can you be here tomorrow? Yeah, okay.
All right,
We'll do
on
that.
this one, so.
So as part of the PTI, do they pay? Because the problem is that I don't want to do a 6-month PTI. We get to the 6th month and it's got to be all in one payment and she hasn't done anything.
Judge, I think that's the reason why we're doing 6 months, so that she can make a monthly payment.
But are you sure? Because typically if you have a restitution bill, they cannot divvy it up. They cannot.
I can't do the restitution, but it has to be supervised so that they could do like a restitution memo, which is what I was looking for, about to make payments, so they're supervised. They would make payment.
Can you do that? Can you guys accept the money in like some kind of trust?
What we'll have to do is change it, because on this, it says the 12th floor of the DA's office. If you make it like as a condition of the PTI, then we can accept it that way, and then I'll give you the restitution of what I give you the other.
Because otherwise, from what I understand, it's got to be all in one lump sum. That's
Yeah,
why.
if we do the restitution bill, it has to be in one lump sum, judge, but when the supervisor, I know that they're allowed to do it, so I'll do what.
Are you okay accepting the money?
Yeah.
Yeah, okay, then let's do it like that.
Yes, yes. So change, should I change it then from where it says their DAs and put it as a condition? Okay.
So Randall was her last name?
Yes.
Ms. Randall, come up.
Yeah.
So the total was 1,000 and, so 1,100. Okay. So, you know, they're really bending over backwards to help you out, Miss Randall. And I hope you really appreciate it because we don't do many of these these intervention agreements where you get to pay as you go. It's all in one lump sum because, I mean, really, imagine how many thousands of people that we supervise. It's just, not only that, it's going to cost you more because you have to pay to be supervised. So, that's around $183 a month. Are you going to be able to pay that? Are you sure? Because if you miss a payment, even one, we docket you back here, and then you're looking, I mean, the agreement is gone. You don't get to miss payment and then go back. This is one opportunity that we expect you to pay every month on the same day. Do you understand? So tell me what day would be best for you to pay the 183.
On the 15th.
Okay, so every 15th, she owes $183 or $184. Okay, if you miss a payment, you're going to be put back in here in court. And at that point, the PTI agreement is gone. Do you understand? So please pay faithfully, do what you need to do. Can I waive the super fee? I'm going to waive it because I'm trying as much to make sure that it happens, but I'm not going to be very understanding because your case is already going to be over 250 days old by the time we get back here, if we do. So make sure that payment, there's just no excuse. I'm really taking off all the money that you would pay otherwise. You understand? Well, I mean, just make it happen. We don't ask for much. We just imagine if someone were to do something, if you get something of yours, one of your most prized possessions like your car, and beats it to hell. How upset would you be? Imagine if someone, do you have kids? Imagine if someone were to take one of your kids and beat them down so much that they have to go to the hospital. Now, on top of that, you're going to have to pay all these medical bills, which is insult to injury. How fair is that? That's all we want here. We're not asking for much. We just want fairness. Do you understand? Good luck, Mr. Engel. So, hey, let's do a status 3 months in to make sure that she's in compliance. And then if she's in compliance, and at that point, we'll continue for the remainder. Okay? All right. Thank you so much. Oh, we forgot to talk about one, DeLorean.
He didn't make it up, so I've been rolling it. I think Friday was his first time on Docket.
No, he's on bond. I thought he was supposed to go turn himself in.
DeLorean Walker.
Yeah.
Yeah, he's on my jail doc. Have you found out?
Oh, he is. They must have just done it because I didn't even see the terrorist threat. And now
It's an AKA Walker. I wrote that on your docket.
they must have literally just set them on. Okay. Sorry. You are Mr. Ramirez.
Sir.
Mr. Ramirez, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. So we're abandoning the enhancement, guys. Is that right?
Yes, sir.
Okay. You were enhanced to a 90-day minimum because of their prior criminal history. They're going to abandon the enhancement. However, you're still looking at 90 days in jail with credit for the 95 days that you have done. Is this how you understand the agreement?
Yes, sir.
You need to understand something really important, Mr. Ramirez, that this now will reflect as a conviction on your record. If you ever pick up another evading arrest, this can be used to enhance your punishment to a felony offense. And if you have prior felony offenses, those can be used to enhance you over and over and over. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty?
Yes.
So it looks like he has 3 cases with this. He's got the theft case, the evading, and then the failure to ID. So are the other 2 going to be dismissed? Okay, is this how you understand it? All right, how do you plead to the evading? How do you plead? Guilty or not guilty? To the evading. Okay, all right, I'm going to find you guilty on motion of the state. The other 2 cases will be dismissed. And good luck to you, sir. Okay, thanks, Adam, for coming back. So I have a motion to withdraw Sebastian on DeLorean.
For a conflict issue.
Okay, so have you already?
Point until somebody, until the defendant comes up.
Okay, then I'm not gonna grant this then. I'm gonna hold it until tomorrow. Hopefully we get him back and then at that point. But I don't want to be in there without one. Okay, I think, are we done?
No, Judge, Brandon's case. I think they're out talking. Oh, is he out there? I thought I heard her talking. Judge, you did tell me, yeah, I never did. Oh, wait.
Elena? Is that the last thing?
Yes, Judge.
I'm trying to call her and it's just not even going through.
In the elevator.
I guess that she wants a trial, set it for the.
She did. The video was required appearance for a status check.
Okay, hey, so she wants a trial date. So I'm setting their case for trial on the 29th, September 29th for Banks.
Okay.
Okay. And then just no, that's it. So no more